and our agenda for today and some housekeeping notes. And then I will be out of the driver's seat largely for most of this event and be putting you guys in it. So on that note, I'd like to just speak that this is our event, Ensuring Rights-Respecting Approaches to Platform Governance in Sub-Saharan Africa, Global Guidance and Multi-Stakeholder Perspectives. It's a collaborative effort between GPD, between the OHCHR BTEC project and Paradigm Initiative, and it's been very much a joint venture between all of us to ensure this event can happen, so I'd like to also extend my thanks to them and also to FIFA again for letting this take place. I really think that FIFA is one of the perfect venues for having this conversation. It is really a unique opportunity, or one of the few unique opportunities to allow kind of multi-stakeholder and collaborative efforts from a regional focus, particularly when tackling complex issues such as those surrounding platform governance. Today, what we'll be doing is focusing on platform governance from a regional perspective. By platform governance, we're taking a kind of large, open-ended, holistic view of the term, so both the regulatory efforts by states and the obligations and duties they're imposing on online platforms, as well as the actions that platforms themselves are taking internally, such around content moderation, for example. So hopefully that framing is helpful for everyone. What we'll be doing today is trying to really unpack and tease out the drivers of regulatory trends taking place across the region. We'll be looking at the impacts on human rights and hopefully how to mitigate them. We'll also be taking a look at the role of international and regional standards and guidance and how they can help inform rights-respecting and inclusive policies. And we'll also be looking at kind of what can be done in terms of multi-stakeholder and collaborative efforts and what best or not best practice of companies is taking place. Again, our ultimate goal is to foster kind of a further understanding, but also I hopefully imagine like building more of a community of practice around this issue and bringing people together and then taking it hopefully the next step about some follow-up actions and some more actionable things that we can do together to move the needle forward. In terms of the agenda today, which you'll find printed in a lovely magenta format on your tables, is we have 3 roundtable discussions, and they're designed thematically, and they're designed to set the scene. And you'll have the opportunity to hear from experts from across the region, civil society, private sector, international organizations, and others. We'll have kind of panels at the very beginning of them, and then they'll open to a broader discussion. So I'm truly encouraging you all to ask questions or engage with the speakers in their interventions, fostering more of a dialogue than one direction speaking. And those will be thematically aligned by platform regulation trends, by the role of international guidance, and also by multi-stakeholder and best practices. After that, we'll have a bit of a break, and then we'll be turning over to the more dynamic and hopefully fun part of this event, which is going to be breakout groups. We have 3 breakout groups, and they are also thematically aligned broadly amongst the themes of kind of information integrity, looking at disinformation, hate speech, and trends around that. Secondly, around AI and algorithmic manipulation. And thirdly, around the impacts on marginalized and vulnerable groups. And you'll be asked to break out based on your level of expertise and your interests, of course. What I'd like you to do, though, before that breakout session and before we then come back to plenary with those in the room during those breakout sessions, that'd be really helpful. Basically, at the end of the breakout session, we'll come together in plenary and again find and look to next steps and what the outcomes are for each group. We have some guiding questions that I'll be sharing with you so that it's not a complete unguided effort in terms of the breakout sessions which can happen. But hopefully that gives you a decent overview of what we're doing today. So yes. Just some final remarks that this is being live streamed, so it's not Chatham House rules. It's open to the public. Also, that we do have translation, English and French, being in Dakar. My French is atrocious, so I'm not going to try to speak in French. I'll be speaking in English, but for those who need translation, it's provided on the table throughout the session. In addition to that, I would like to ask everyone to positively contribute. I know that a lot of us perhaps are not new to these concepts. Some of us might be, but I really do encourage us having more of a dialogue than, again, speaking in one direction. And With that, I'd say also please, when you're making an intervention, do just briefly introduce yourselves. I think we're too big of a group to go around the room, but hopefully I can see we're already having some discussions and introducing one another, so it'd be really helpful to have that. On that note, I'm going to pause, and I think we'll be handing over to the first roundtable of the day. But again, thank you so much. It's a serious topic, but also I hope you enjoy yourselves and have a good time. Cheers. Virgin? Yes.
Only women? Bonjour. I'll switch to English, but I want to say bonjour first. Thank you very much for having us in Sénégal, in Dakar. Merci de nous avoir invités à Dakar. I'm very glad to open or to moderate this first roundtable, which is really about a key topic that will be very decisive for the future we have ultimately. How do we shape collectively the online civic space? The online space, which really is where many people now participate and influence their futures. So I'm very excited to do that. Maybe quickly saying who I am. I'm Birgit, and I work with the UN Human Rights Office, so normally based in Geneva. As I said, we are talking about how do we organize the online civic space and so that it's good for people. Yeah? And the tools we have for this are really human rights. Human rights were made up to decide how people can express what they want and shape how the world is going to be. So freedom of expression, of course, is a really central piece of that. And the other right I want to mention is privacy, simply because it's less often or less thought of, and it actually has become more important in the digital world than it used to be in the past. Also, it was always important, of course. So I'll stop there and ask the first question to Angela. Could you speak a little bit about trends in platform governance in sub-Saharan Africa, and really also look at it from a corporate responsibility perspective, please?
Thank you so much, Bridget. My name is Angela Minayo. I work at Article 19 Eastern Africa. I lead the work on digital rights and policy. Thank you so much for your question. I'll just pinpoint some of the interesting developments we are seeing. I think it goes without saying that Article 19 works on freedom of expression, access to information, and we champion this as well in tech and how technology is deployed and developed. So there's an interesting case in Kenya. Some of you might know about it. There was a preliminary challenge to the jurisdiction of Kenyan courts to adjudicate on a matter involving Meta. The decision was given, I think, yesterday, and the Kenyan courts upheld the fact that Meta can be tried, or cases against Meta can be heard in Kenyan courts. I think that really sets a trend that might spiral in other countries in Africa, that will start not looking at the jurisdictional presence in terms of physical office, but in terms of where the platform where the platform services are being used. And in this case, it was Kenya, as well as where the content moderation is being done. There has also been an interesting shift in having other ways of regulating platforms. So countries in Africa are coming up with things, amendments to their competition laws. So in Kenya, we are trying to see if we can have digital markets be part of what the competition authorities are regulating, and this might change platform governance as we know it. We also have bills that are looking at digital economy and digital opportunities, and this might also present other avenues for regulation. I wanted to talk about political interference. We see this a lot, especially with TikTok. So there was a proposed ban to TikTok in Kenya twice, both on the grounds of propaganda for war, terrorism or radicalization, and of course members of parliament tabling motions suggesting that this platform should be banned, which is quite a draconian step from a human rights point of view. You would think that the right approach will be to engage platforms more on their terms of use, so that we can find a way that platform services are still accessible to people, but we have community guidelines or policies that might address some of the concerns by states. But the state's approach of banning TikTok might also be a borrowed playbook from the United States and African governments, saying if the United States can propose the ban of TikTok, we might as well follow suit. So we've seen these talks of banning TikTok in Kenya and Tanzania, and I think that is quite concerning in terms of freedom of expression in the region. Then we've had cases of content filtering. So this was seen during the Kenyan protests, and almost a blanket ban of TikTok or of Twitter X now in Tanzania. So we're seeing content manipulation, at least the traffic of the content, or total blackout of a particular app. In this case, it has always been X. It's also very concerning that X does not have presence in the region. So as a digital rights programs officer, I don't know who to engage. I don't know if I should take a flight to Europe to have a conversation about Twitter X's content filtering and content moderation practices, really. So it is very concerning that some of these teams, we don't know if they exist, because we know that when Elon Musk took over, some teams were laid off, but also the fact that they don't have any presence in Africa at all is quite concerning from a multi-stakeholder point of view and an engagement point of view. You're writing letters to people you've never met, and therefore you miss that human touch that sometimes helps in engaging platforms. There has also been quite a lot of focus on child online safety and safety of women and minorities online. So we have seen platforms make some attempts of having or addressing these issues. TikTok has appointed a board, I think a safety advisory board. One of the persons sitting on that board is Lillian Kariuki. She is a CSO executive director for a think tank, and I think this is a good step. Having more CSOs involved in online safety policies for platforms is a welcome step. We hope that these advisory boards are not just bureaucratic and ceremonial figments of the platforms, but we hope that they can actually change policy from a more substantive level. Finally, and this is something I'm very much interested in, is how platforms are changing their own community guidelines and terms of use. We are seeing a lot of changes in terms of use regarding AI-generated content. I think we're all aware of the oversight, of Meta's Oversight Advisory Board's opinion, as well as the fact that we are now seeing a lot of AI labeling. So AI-generated content are being labeled. I think this is a welcome step. It's at least embracing generative AI as a way for people to make content and not necessarily say that any content made by generative AI should be banned. So it's better to have it just labeled unless it's a community guidelines, which is when now the content moderation policies should be applied. Other interesting things I've seen in platforms is how they're also trying to deal with misinformation and disinformation. I think we're all aware of X's community feature that gives more context to possibly misinformation or disinformation content. I will leave it at that, and I welcome the panelists if they have any additions. Thank you.
Yes, thank you very much. That was an impressive list of challenges. And I think the interesting thing is really on some of them we know exactly what is wrong and how to address them, but on some of them we just don't really know yet what the answer is. We have never had as humanity an internet with so many users. So really thinking about what does it mean, how do we make sure that we hear the voices of everyone, or as much as everyone as possible, and figure out what is the right answer to some of these questions. I think is really, yeah, people who are allowed to do that for 3 hours are very privileged, I would say. And I was very pleased actually to hear you mention the competition laws, because I've always wondered whether that's maybe an underused mechanism for, from the human rights community's point of view to address some of the issues. Anyway, I'll move to our second expert, Ayman here from Meta. And I'd like to hear from you, I mean, reacting to this impressive list of challenges from the point of view of one of the companies who receive many asks, I know. What would you like to share with us?
Thank you very much. My name is Iman Khair. I'm a diaspora policy manager working with Meta, specifically for the team responsible for Africa, Middle East, and Turkey. And thank you for having us here, and really excited about the discussions that we'll have here today. So I'll try to speak about 3 things, like generally, like what are the trends we're seeing, but then focusing on 2 specific regulatory trends, and then speak about how Meta usually engages with that. So in terms of platform governance, one of the things we're seeing is we're seeing a lot of efforts from policymakers to update legal frameworks based on, of course, the challenges of the digital economy, innovation, and also maintaining public order. And within that, we're seeing increasing demand for accountability. Okay. Thank you. Can you hear me now? I naturally have a very low voice. Okay. So also, one of the things we're seeing is that there's an increasing demand from platforms, accountability of platforms, and by that, it's specifically about compliance and about effective moderation. In addition, like, this is a year of election, and because it's a year... Can you please slow down? I'll do that. And 2024 is a year of election. Knowing that this is a year of election, we're seeing that election itself are sparking and accelerating a number of regulatory development in the continent. Within that, we're also seeing 2 things that I want to point out too. Like, one, that there's a growing influence of other, like, borrowing of these regulatory frameworks from other regions. And with that, it's specifically the EU DSA and the UK Online Safety Act. The other thing we're seeing is that there are also attempts, regional cooperation attempts. So with that, we're seeing the African Union principles and guidelines for social media use during elections. We're seeing REFRAM, which is the media regulators in Francophone Africa, coming together. And we're also seeing ACRAN, which is the Africa Regulatory Network. So the 2 trends that we're seeing specifically in Meta and we're like following actively are 2 types. One, we're finding that there's a rise of omnibus bills in SSA. And with that, it's like basically a number of policymakers and regulators are trying to address multiple issues under one single legislative framework. So Of course, that poses a lot of complexities. One, because there's so many issues, there's limited understanding of these issues and topics across the board. There's limited transparency, and there's limited stakeholder engagement. And because of that, you can imagine that the outcome of this can be poor. And the factors that actually drive these omnibus bills that we're seeing is, again, the DSA inspiration element, where by borrowing from the EU DSA, it sort of legitimizes for government these regulatory positions. Another element that we're seeing is elements of the digital authoritarianism. So what we're seeing is that the main challenges here is interpreting what it means to have national security public order, right? Or like, what does maintaining public order look like? And what we're seeing is that it provides instances where criminalizing disinformation and sometimes like having hefty penalties is what comes out of that. Finally, fraud and scam is another driver of that. And the forefront of this legislative initiatives, like because fraud and scam generally globally has increased, and within Africa, Middle East, and Turkey has increased more than 50%. So the second type of legislations that we're seeing is that single issue regulations. And I think to Angela's point, we are seeing a lot when it comes to misinfo, to child safety, to protecting family values, and also cybercrime laws. While they're not the same, when you speak about misinformation, again, it's a catalyst for this reactive lawmaking, where you speak about tackling public safety concerns, but at the end, it becomes a smokescreen where you control the dominant narrative and you crack down on free speech. Family values is another one, where family values feels to be a code for LGBTQ communities, whereby protecting these family values can mean that this like marginalization of this community offline is seeping into the digital space. And again, this protection is also not just making it harder for this community or marginalizing them further, but it complicates it. It complicates the intermediary liability regime for us. Because for us, it speaks about, are we really protecting are we liable for the dissemination of LGBTQ content and requiring this like proactive actioning. And of course, it creates like this significant legal and operational responsibility. But of course, like the main challenge is that it also contradicts with international human rights law for us. The only thing I'll say about cybercrime law is usually meant to prevent harmful content. Again, harmful content can be a guise for so many things, and what we see is that it incurs a lot of harm to users and rights, to users' rights and freedoms. And there's like a great report published by GPD and Article 19 for West Africa, which speaks about this. I'll just briefly, if you give me 2 minutes, speak about what Meta, how we as Meta, deal with that. So the first thing, we realize that there's a lot of people who are using our platforms, and the reason they're using it in what we call computer-mediated politics is that they're finding that space which they're not finding offline to gather, to organize, and to speak about social and political issues that they can't really speak about offline, and that's where they affect change in society. So we understand that, and that's why we play an active role or try to engage in dialogue or platform governance, specifically to help work or shape these, developing regulations within SSA. So we work together with the stakeholders, and we find ourselves, because of that, in this intermediating position between the citizens and the governments. And what we do is that we have a corporate human rights policy, which we adopted in 2021, and it guides the work across the company, not just my team, but across all the teams in Meta. And the two main things that we're seeing and that we work on is that we had a comprehensive human rights salient risk assessment, and it showed two main issues. The first thing is that there's overbroad government limits to content, and the second, that there's overbroad or unnecessary government demands for user data. And I guess the question is, do we give them the data? And when it comes to enforcement, there is a robust regulatory compliance policy that we at Meta follow. and I can speak about these takedown requests that are asked by the government later on if there's a question. But basically, we follow the GNI principles when it comes to that, and loosely, defining what the principle is that we follow, of course, human rights law, and if there is a conflict between local and international human rights law, so we need to err on the side, and I'm paraphrasing, need to err on the side of human rights. And that regulatory process has a 5-step, which is legality, legitimacy, necessity, proportionality, and external risk. I think I'll stop here, but just basically saying that we prioritize the freedom of expression and safety online in the different aspects in how we manage that platform governance. Thank you.
Yes, thank you very much. Also, many very, very interesting points. Especially, the mentioning of cybercrime reminded me that we have a new convention that was adopted recently that has some concerning elements as well. So, so where you have another kind of another set of international law, sometimes even going against human rights. So I'll move to our third speaker, Victoria. And I'd like to ask you to speak maybe about the concrete regulatory proposal in Nigeria, the Harms Protection Bill, which is one of the things you just mentioned as triggers for laws. And if you could also kind of explain a little bit to what extent, and if yes, to what extent it addresses multi-stakeholder engagement. Thank you.
Thank you, Bridget. Let me start by saying first that as a young Nigerian, as early as 7, 8 years old, I was introduced to the concept that freedom before speech may be guaranteed, but the problem comes after speech. So unfortunately, we haven't had a good dossier when it comes to protection of the rights of people to free speech, and more so regarding areas around inclusive citizens-led policy. Speaking of content moderation, it has been a struggle. But I would say, in order to answer the question properly, the context is quite important, because this context has led to, or the historical context where citizens have been excluded, citizens, industry, stakeholders, basically policy stakeholders have been excluded from the moderation scene or regulatory scene, has led to 2 things. One is distrust between the government and the other policy stakeholders. Secondly, this distrust has created a reactionary posture in most policy stakeholders. And so in the past, for instance, where we had I wouldn't say in the past because it's still a struggle, the priority of the government has been security first, not citizens first. And so multi-stakeholder engagement has struggled to find its space between or within that scene. Take, for instance, the Cybercrimes Act in Nigeria. It was one of the foremost regulations that tried to, regulate or, moderate content online. The other was the failed social media bill in 2019. And what all of this has done is to put citizens on the defense. And so an organization, when Bridget is asking about the concrete steps that have been made towards multi-stakeholder engagement, a few months ago, after the social media bill faced a lot of opposition from many Nigerians, home and abroad, and other stakeholders, including platforms, what happened was the National Information Technology Development Agency had reached out to an organization that I co-founded and permit me to do things in reverse. I didn't introduce myself properly. My name is Victoria Manya, and yeah, I am a researcher at the Leiden University in the Netherlands, but I also co-founded an organization called the Advocacy for Policy and Innovation in Nigeria. What we do is to bridge the gap between policy makers and policy stakeholders, hence the question about multi-stakeholder engagement. And so the NITDA, which is one of the foremost regulatory organizations or agencies in Nigeria, reached out to us to say we have had several attempts, or we have made several attempts to put this out, and it is all based on national security, and I think the speakers before me mentioned this as well. So they fix national or place national security on this high pedestal, almost as though it shouldn't be touched, it shouldn't be negotiated. But the point from people and many of the oppositions were based on the fact that you cannot put national security on such a pedestal that you impact the rights of people. When you do that, you get a reaction which in turn impacts negatively national security. And so what we had to do was to sit down with NITDA, and we went through 3 phases, so what we like to call the 3-phase approach. The first approach was the recognition. We had to have conversations with this regulator to understand that the digital landscape is evolving faster than traditional content moderation approaches can handle or can manage. And also, in order to protect people, especially the vulnerable, like the speakers before me have mentioned, we need to adopt practices that are, 1, anticipatory, and 2, preventive in nature. We cannot be playing catch-up if we indeed want to pursue national security. And so what happened from there was NITDA commissioning the organization to go forward with a plan for content moderation bill. So what we did was to bring we got nominations from different stakeholders, groups, civil society, academia, government agencies that have overlapping powers with this particular regulatory agency that I speak about, and we all came into one room. So a steering committee was formed, the trust building. Everyone came to the table with a long spoon. In Nigeria, we say if you want to have dinner with the devil, make sure you use a very long spoon. And I use the devil because I know we are streaming right now. The government is not the devil. I'm just using an analogy. And so people came with that distrust on their it took us a long time, and there are certain people in this room as we speak that are members of the steering committee. Most people were quiet in the first meeting. In the second meeting, people were asking, so is this like a tokenistic encounter or activity where you say you have involved stakeholders but you didn't? So this question was directed towards the regulators in the room. And so we had to, go back and do some background work. And NITDA had to come up with, basically a strategy to commit to the multi-stakeholder engagement for real. And this brought us to the next phase. So at the balancing of scholarships, let me put it that way, we had 2 views in the room, and it was polarized. There were barely any middle grounds. And we had to find a way to balance these perspectives in order for us to move into the core proposal writing. The first was those who were most concerned about human rights. So there's human rights, there's no question, it has to be 100%, civil society kept pushing, every other thing has to be built around, or regulations have to be built around the rights of people, and for some of them, it should be blanket. Why are we even trying to moderate or clamp down on the voices of people? But the second scholarship, where of course the government leans towards, was basically saying that we need to regulate content in order to protect people online. And they complained bitterly about the inertia that is created as a result of the Good Samaritan content moderation principle. Speakers before me spoke about, the examples from the US, the DSA. We also looked within the steering committee. We had some research done, basically presenting all members of the steering committee with, examples from all over the world, and some of them brought examples from Austria, from Brazil, from India, just to buttress their points. So you can imagine where Nigerians are gathered in a room and trying to balance, very strong biases. But three things that we agreed on, irrespective of the dissenting scholarships, were that one, broad transparency. So we agreed that the overall openness about policies and decision makings across platform should be at the forefront or should be a priority. The second was systematic transparency. We agreed that there should be clarity on process and systems like content moderation and algorithms. The third was on individual transparency, meaning that platforms must ensure users understand how their data and contents are being handled. So this brought us to a core decision-making point. Should we go on with content moderation because it sounded very mechanical to many people in the room, or should we find something else? And so when we researched a lot, because let me mention at this point that most of the complaints in the room from one part of the scholarship was that the government is regulating what they do not understand. And so it was also important for us to have some evidence, to back each of the arguments, and in order to find a real balance, because we realized it was a huge, or it required a huge balancing act. So what we did was finally decided, since we all agreed on these three parts, that we would go for online harm protection, where we capture content moderation. So for us, it was more holistic, it was more co-regulatory, it was more preemptive, it didn't play catch up, it wouldn't put citizens at risk, and so we thought to go with this. And some of the practical things that were infused in the proposal were, one, the co-regulatory approach, sharing responsibilities across stakeholders. What we did was to first write a white paper. The white paper has the proposals, and it's gone out to get feedback from various stakeholders. And then the other thing we contained in the white paper is a center for online harm protection. Basically, this center will coordinate stakeholders. Remember what I said about the overlaps, regulatory overlaps. So when we also didn't want a situation where other regulators who were not yet involved in the process, would come up with regulations that basically take us back to where we started. So we had to create a proposal where every regulator, no matter how minute or significant your impact on moderation is, would be involved in the process. So the coordination would have representation, the coordination of the center would have representation from all parts of all groups within the space. We also made provisions for transparency, accountability, a lot of the things that everyone in the room would like to see, the respect for human rights, I remember the three transparency elements or pillars that we agreed on, right? The broad, the individual, so all of this have been galvanized into a proposal, and it's been sent out for feedback from various stakeholders, and we're hoping that we are able to really capture a balance. And I must say here, a small caveat, that this isn't a utopia. I'm not trying to paint one, because we're not where we are, and the process isn't removed from the overall context, the stories that you hear from Nigeria, taking us back to the Twitter ban of 2019, where social media was used to enhance the voices of people, for collaboration, for mobilizing communities. And then what did the government do? They ban. So one of the things that we have put, or the mantra that we have tried to work with so far, is to engage stakeholders or involve them extensively and collaborate with them closely. Thank you.
Thank you very much, Victoria, for this very hands-on example of a process. Maybe the one point that resonates, I think maybe 2 points. There is the question of stakeholder engagement, which, the question is, how do you really do it? Because you can obviously, it can be an indefinite number of people who feel they are stakeholders. So there is this balance that needs to be struck, but there will be a separate roundtable about this. But I really think where we still have a big gap to fill is the question of evidence. We don't know much. I feel that much of the lawmaking and policy making is still done without really a very robust evidence base, and maybe that's one of the things that we can try to address a bit more comprehensively in the near future, or even when there is evidence, by the way. People don't necessarily take it into account, because just there's such a strong impulse to just take down content that's, they don't like. Anyway, thank you very much to all the panelists for the first round, and I'll open the floor. We don't have very much time, but I'll open the floor for some Q's and A's. Please, don't be shy. Yes.
Maybe we could take 2 or 3 questions in the audience, if anyone has any, and then allow any responses. Don't be too shy. Yeah, great.
Thank you very much, Ian, and thank you to the panelists for really setting the scene and highlighting some interesting trends and developments across the region. I think it's not really a question. I just wanted to pick on something that Angela mentioned, and perhaps Mary Stella can also jump in, because she's from South Africa. She's based in South Africa. At least she might have an idea around what's happening there, around the issue of competition authorities. I know that the Competition Commission in South Africa also did a market inquiry around, payment of news by platforms. They met with Google. They met with Microsoft as well. And so it's definitely a trend that we might see also happening or being taken up by other competition authorities within the region. I mean, South Africa has always been a trendsetter as well in some of, these issues. So seeing them taking on this task of doing a market inquiry and meeting with both media stakeholders and also, platforms and companies to have a discussion around payment for news is quite an interesting development. And I was just wondering also, Mary Stella, if there have been updates post the inquiries, if there's been a report as well around that inquiry, and what the current position is from the Competition Commission in South Africa. Thank you.
Maybe we'll just take one more question and then allow the panelists to...
Good morning, everyone. My name is Moses Umara. I'm from Uganda. My question is, first of all, thank you for sharing your experiences with us. I love it. And I just want to know if probably there is that one major challenge that you probably encountered during your work, especially when it comes to the issues of government prioritizing security, and they attribute that one to closing down the digital spaces for different people. So how did you maneuver through that challenge, if at least you came across that challenge, trying to divert government priority from security to the issues that CSOs really wanted government to address? Thank you.
Okay, if there are no more questions, I'll look at the panelists. I don't know who can speak to the South Africa question. And then the other one was for the...
Okay.
Yeah?
Okay. Okay. I could go. Yes, thanks for that question. And I would emphasize that we are still maneuvering. The government would never, I guess we've come to the realization that the government will never let go of national security as that, blanket cover. It's almost like the magic wand that they have. And so sometimes we also fear that they have committed to one thing. We are hoping that situation, the politicization of moderation and the digital space does not force them to go back on the commitment that they've made. But one of the things that I said when I was speaking is the balancing of priorities. We had research or heavy resources go into researching how to balance the need for human rights, the respect for human rights vis-a-vis, national security. And so I would say that was one of our major strategies. We ensured that for each stakeholder present in the room, a research paper was done to address their biases. And I would also emphasize that we recognize the heterogeneity of each of these groups. So we didn't have one research for everybody. We had research that was specifically addressing the various biases within the room so that each of the stakeholders could find themselves within the documents that we put together. Thank you.
Thank you so much. Yes.
Okay. I can address the South African question because I understand the context, but Maricela, please feel free to jump in. So there's a very interesting debate ongoing on how news agencies should be compensated for their work, especially given that some of their work is being used to train AI models. The conversation is way more advanced in Europe because you have very robust competition authorities and frameworks that at least work. But in the continent, I think South Africa has made the most stride. So in Kenya, when we were commenting on the competition amendment bill, we did it as joint CSOs, and one of the parties that was part of this joint statement was the Kenya's Editors Guild, and actually that was their main concern regarding regulation of digital markets, is how can we fairly compensate news agencies. And I think this is a conversation that can feed even more into human rights, labor, and digital markets. I'll just leave it at that. Maricela, if you have any developments from South Africa, please feel free to chime in.
Thank you. I'll just do it briefly. I do agree with you, Nompilo, on the importance of the inquiry that is happening in South Africa. As yet, I've not seen a report, but I remember when I was engaging with the process and talking to colleagues such as Media Monitor in Africa who are before the commission and also submitted there. I think one of the key things that stood out from this process that other African countries can actually think about through similar process is that it was very important towards media sustainability, because we link here in terms of the role of media online right now and how they are being incentivized in terms of how they are being paid has an impact on currently media sustainability in terms of the competition that they are getting. And so as other countries think about it, we also have to see it as a way to push for media sustainability in Africa. Thank you.
Thank you very much. Yes, Iman, if you...
I just want to weigh in into the government element. So I think as a platform, one of the things that we see is that we receive takedown requests from government. So they reach out to Meta asking to take down specific pieces of content. So one of the things that, like first I want to say, maybe the room knows it, is that we have a transparency center where we show the life cycle of which government asked for what piece of content to be taken down and what was the decision. But also wanted to just share a little bit about that. So usually when we receive a takedown request from the government, the first thing we do is that we check if it's against our community standards or not. If it is against the community standards, then we remove it. If it's not against it, then it goes to another level where we conduct an independent legal review based, right, like is it against local law or not? If it is against local law, if it's against local law and it is against human rights law, we remove it. If it's against local law but does not go against international human rights law, then it goes to another level, which I spoke about, which is the elements of, the legality, the legitimacy, necessity, etc. And then after considering all of these elements, we comply. We either comply with the takedown request of the government and we publish it, or we take no action. And depending at the end, or like which has the largest societal benefit in that specific request. Thank you.
Question to that. My concern will be, and this has always been my concern, that essentially platforms are mini courts. You're hearing matters on freedom of expression and making decisions that can either violate or uphold freedom of expression. So at what point are the users also given an opportunity to be heard, because their content potentially could be removed from your platform?
That's actually a great question. So first of all, like, I think one of the things we do is, like, as a platform, is that the number one thing we need to do is mitigate risk, right? It's not about arbitrating the truth, but about mitigating risk. And also, of course, if you feel at any point that this doesn't resonate, like doesn't support freedom of expression, etc., then one of the things you could do is come back to the Meta team, engage with them and say that I disagree with that, right? And of course that can, the decision can be reviewed and can be upheld. If not, we actually have the oversight board, which you also spoke about. And the oversight board is a mechanism, and it's actually like a court, right? So what you do is that you go to the oversight board and speak about a specific instance where Meta was, unfair to you, in the lack of other words, like unfair to the decision that they've made. And what the oversight board does is that, acting like a mini court, is that it would review the decision, it would have a public hearing about it, and then make a decision at the end, either upholding what Meta has, said, or advising Meta to bring back that piece of content. And sometimes, by the way, that leads to a policy revision of our community standards. Thanks.
Okay, I think our time has come to an end. I would like to thank everyone. I think we've put many, many interesting questions on the table collectively, and many of them will actually come back in the course of this morning. In any case, I would very much like to thank the three panelists for sharing, and I hand over to Ian. Thank you.
Thank you all so much. We're just going to get set up for the second roundtable now, so just bear with us a minute. Thank you. Mr. Matar Sal is in the room. Just come to the front. If I can get tech support up here. Hello everyone, thank you for your patience. Yeah, fantastic first panel and roundtable. Thank you so much for moderating and all of your interventions. We're going to be changing directions right now and looking at international guidance on responsible business conduct and the contents of platform governance, because as we heard, there are a lot of efforts in terms of regulatory efforts by states. There's lots of different corporate actors making decisions, but how is this all being underscored by existing guidance and kind of new regulatory aspects that we have at the global and regional levels? So that's what we'll be exploring today. We have some fantastic panelists up here with a wealth of knowledge and experience, so I'm going to turn over to them. And my first question goes to Mary Stella Simiu, who also just got her doctorate, so huge props to her. Wouldn't want to celebrate her. But also, Mary Stella, can you, so I'm going to move forward. Can you tell me a little bit more about the kind of international standards and guidance at the international and regional level that we're working with that can kind of guide our efforts today? Thank you.
Okay, thank you very much, Ian. As you heard, my name is Mary Stella Simiu. I work with the Center for Human Rights at the University of Pretoria, which is an academic institution as well as an NGO that works on issues of human rights advocacy, training, and education. And thank you very much for the conveners for this panel. And I think for our discussion, we have to start from international human rights law when we're talking about platform guidance. Most of our discussion came from the fact that we would see that self-regulation of platforms was not adequate, especially when you look at it from the lens of human rights, that it was not adequate. And when you think about human rights, we're thinking about, freedom of expression, access to information, privacy, assembly and association, as well as political participation, and how we see it playing out on platforms and how it impacts how we exercise our different rights in this context. And so when we talk about rights, of course, we think about the seminal documents that protects these rights. At the UN level, we have the International Covenant on Civil and Political Rights. And when we think about the African continent, we have the African Charter on Human and People's Rights. And these are the seminal documents protecting our different human rights. But more and more, when we see more players in this space, we have to now look at whether these norms that we have are adequate enough to protect our rights in this digital age and every other developments that we see that are affecting our different rights. And when you look at international law, and we look at the different bearers of responsibility at international law, we see that it's categorized in different ways. The states are the primary duty bearers when it comes to international law. They have a duty to respect human rights, they have a duty to protect human rights, and they have a duty to fulfill human rights. When we look at the other side, where we have non-state actors such as platforms, largely the discourse is around the right to respect. They have an obligation to respect human rights. And so what do we mean when we talk about duty to respect, duty to protect, duty to fulfill? So respect under international human rights law is more a positive obligation, the obligation to actually refrain from undertaking any actions that curtail the enjoyment of human rights. But when we go to the other two, which are still under the state's obligation, is the duty to protect is more of states having a duty to protect individuals from human rights abuses. In this case, it could be from platforms. Then we have the third one, which is the duty to fulfill human rights, which requires states to take positive action. It's a positive obligation for states to take positive actions to facilitate the enjoyment of human rights. So positive action could be legislative in terms of the laws that are being developed, it could be judicial, it could be administrative, but either way the state has to undertake a positive action in that regard. But when it comes to non-state actors and relevant to our discussion today, platforms, largely the discourse has been around the duty to respect in terms of you have to refrain from undertaking actions that will curtail the enjoyment of human rights. And when you think about the norms that are developing around this, the guidelines, the principles, I will zero in on a few because we have a very short time for the panel, so I'll zero in on a few that I think are important for our discussion. And one that has featured a lot in the discussion has been the UN Guiding Principles on Business and Human Rights, which we'll discuss more, I believe, in the course of the day. These UNGPs were endorsed by the Human Rights Council in 2011, and basically it has this tripartite structure where it looks at states' obligations to respect, protect, and fulfill human rights, and the responsibility of business, the second part, the responsibilities of business to respect human rights, and the third part is about access to remedies. And basically what the UNGP does is to articulate the responsibilities of business enterprises with regards to human rights. It calls for the development of relevant norms at international level, at regional level, as well as national level that can effectively protect against business-related abuses, and it becomes very relevant to our discussion today when we look at platforms. And the important thing about the UNGPs is that I think it's a very important document, one of the very important documents when you look at it more holistically in terms of guiding platforms, in this case, in terms of what are their human rights obligations and what they need to undertake in this regard. Larger platforms have actually come on board. Some of the larger platforms have come on board and committed to upholding the UNGPs, but as we look at it and review assessment, assess the implementation, we see there are still gaps when it comes to policy, there are still gaps when it comes to transparency, and that was mentioned in the first panel, as well as gaps when it comes to implementation, and there's something that there's need for more action in that regard. Moving on to the African continent, I'll zero in on the 2019 Declaration on Principles of Freedom of Expression and Access to Information in Africa. This soft law instrument was adopted by the African Commission on Human and People's Rights in 2019. It was a revision of a 2002 version, and basically what it did is be cognizant in terms of how to protect freedom of expression, access to information, and other digital rights in the digital age. So it's relevant to a discussion when it comes to Africa. And the African Commission, I'm sure for those who know, it's a human rights body that has the mandate to protect and promote human rights in Africa. So it's a very important organ to this discussion. And what the declaration does, and I'll just zero in on one provision on internet intermediaries, and that's Principle 39. It does articulate some of the responsibilities for internet intermediaries and platforms coming in this regard, and they include, for example, issues of net neutrality in terms of ensuring access to all internet traffic is equal and it's done without any discrimination. It talks about mainstreaming human rights safeguards when it comes to issues of content moderation, when it comes to issues of filtering content. Platforms as well as other internet intermediaries are required to consider the implications, the human rights implications, be it freedom of expression, be it access to information, be it transparency. It calls for the provision of appeal mechanisms where that needs to be, and you see here the link with the United Nations UNGPs in this regard, as well as providing effective remedies. And so here you see that whole concept of businesses required to respect human rights and what they have to undertake in that regards, including their human rights due diligence obligations in this regard. That particular principle, Principle 39, also calls on states when it comes to requests for removal of certain content. It provides certain standards that states have to follow with regards to such requests for removal of content. It also calls for instances, and it does put a caveat here, there could be an instance where law enforcement asks for the expedited removal of content or immediate removal of content. It does provide a criteria for that and says it has to be in the incidents where there's imminent harm or serious threat of harm, of death to a person or a child. Then there could be a request for immediate removal of content, but it also provides that this has to be subjected later on to judicial review. And also talks about, we're living in this age where we see a lot of developments with AI and emerging technologies. It also calls for compatibility with international human rights laws and standards. So it is, when you go to Principle 39 of the Declaration, you get to see at least we are thinking about in the African continent when we are developing different norms about the roles of new players who are increasingly playing a very dominant role when it comes to online communication. What's the role of platforms and how can we govern platforms and how should it look like when you look at it through the human rights lens? And I'm sure the other panelists will discuss this. That is, I've just touched on the UNGPs as well as the declaration, but there are more norms that are being developed, and you see a lot of these norms are actually soft law instruments that are being developed in this space, but they are still providing some sort of guidance when it comes to human rights implications of the exercise of rights on platforms. So, for example, the UN Voluntary Code of Conduct for Information Integrity on digital platforms, the UNESCO guidelines, I think we'll speak about it more on these platforms, as well as going back to the African continent, the guidelines on access to information and elections in Africa. It doesn't touch on it significantly, but there's a part when it talks about the obligations of online media platform providers, there's an obligation there when it comes to access to information and what are the context of elections in Africa, where it talks about information on political ads, which has been a very contentious issue when you think about disinformation especially. And so at least the guidelines touch a bit on that, because access to information and transparency and the link to meaningful political participation, the link to more transparent, accountable democracies is very important, and we see the roles of platform in that regard. So the guidelines on access to information and elections in Africa is another normative instrument that makes reference to that. And so basically, as I come to conclude, is what we see, and it was also mentioned in the first panel, in terms of the models that are emerging or have existed when it comes to media regulation and platform governance right now. The conversation is, what approach are we adopting and what approach best suits our different contexts? And as we can see, as I started my presentation, is that self-regulation had been the dominant approach really when it comes to platforms. And there was inadequacy in this regard, and so we see the pros and cons in that aspect, because for the longest time when you look at discourse, media and self-regulation is something that there's a certain segment that has often pushed for media regulations, but we know the pros and cons in that regard. In the first panel, we also talked about core regulation, and we see discussion around that, state and industry role in core regulation. But I think we can even move further and talk about approaches that bring in more stakeholders, multi-stakeholder approaches that not only talks about state, that is not just about industry, but we also see the role of civil society when it comes to norm development, norm implementation, oversight and monitoring, bringing in more players in the game so that we have multi-stakeholder approaches when we have these more and more discussions around platform governance in this day and age that we live in, bringing different players where we can enhance the quality of the norms that are being developed, bring in different expertise, but also ensure that they spread out oversight, monitoring obligations in such a way that there is no too much power on one player, because that whole difference of too much power, there's been apprehension when it's just platforms, there's apprehension when it's just states, and so let's spread out the risks in this regard and call for better compliance and better transparency in this space. But also, we can't ignore what's happening in the EU, because we know the Brussels effect has really influenced the development of frameworks, and so looking at the regional approach of the EU is something we are paying attention to, because it can feasibly affect and influence the development of more and more frameworks in the African continent in this regard. But basically, whatever approach is being developed, I lean more towards multi-stakeholder approaches, is that at the end of the day, the goal that we are looking for is that we need to look at platform governance, particularly in the African continent, in a way that upholds human rights in this disruptive age, in this disruptive digital age. We need to adopt approaches and work together as different stakeholders in this space to ensure that there is rights respecting, as the panel is called, rights respecting approaches to platform governance in the digital age. And I'm looking forward to more discussion in that regard. And so I'll conclude here and leave it to the next panelist. Thank you very much.
Thank you very much, Maricela, for that comprehensive overview about kind of the international human rights law, the UNGPs, which you mentioned, which is a perfect segue to our next speaker, but also the need for contextualizing and considering this guidance in a broader context of the different approaches and models. With that being said, then, Tommy was a great presentation that he has set up for us. So Tommy, what is the role of the UNGP Compass and the other kind of work that BTEC is undertaking right now? If you could introduce that and set us out, and I'm happy to guide you through the slides. Thank you.
Thank you. Thank you very much, Ian. My name is Tommy Wailori, and I work as an advisor for the UN Human Rights BTEC project. And today I'll be speaking on applying international human rights guidance to platform governance in sub-Saharan African contexts, using the UNGP's Compass tool for responsible business conduct. And before I go into that, I just want to quickly add on to what Maricela had said about some examples of international guidance that can be looked into. I also want to mention two key documents that can also guide on platform governance that were championed by civil society, and that is the Manila Principles and also the Santa Clara Principles that were championed, I think, by EFF, the Electronic Frontier Foundation. So having said that, I'll go straight to my presentation. So I think, like Maristella already spoke about the UNGPs, I think some of my job on speaking about it has been done to an extent. So as you can see, it's a result of quite a lot of, it's been a lot of work, 6-year consultative process. It was adopted in 2011, endorsed by global business, civil society, and trade unions. And importantly, it's a global normative framework with a strong political foundation. And it also has principled pragmatism, like it speaks to practical challenges that is faced by business and human rights sector. So from our work as BTEC project, the backbone of the project seeks to, it focuses on how to apply the UNGPs to the tech sector. And we understand that this is a very difficult and Herculean task. And this is why, we also try as much as possible to work with as many stakeholders as possible to also get context on how this can be better, applied in their respective context. So primarily, it focuses on preventing, identifying, mitigating, and addressing risks to people from digital technologies. And like Maristella concluded, it is also working in a multi-stakeholder manner to deliver better policy responses and practical outputs. So as we are all aware, the UNGPs has 3 major pillars: to protect, state duty to protect, corporate responsibility to respect, and access to effective remedy for people who must have been victims of, in this context, technology harms. So moving on, we have 4 focus areas in BTEC. We identify avenues to address human rights risks related to tech company business models, and there have been foundational papers on addressing these risks. So that's number 1. Number 2, which I also discuss in detail as I go on, is promoting robust product and service human rights due diligence, while deepening stakeholder insight as to progress and challenges in implementing the other aspects of UNGPs. Thirdly is remedy, because especially in this part of the world, we find out that online harms are present. Technology could facilitate violence, but at the end of the day, what recourse do most victims have? So these are some of the thorny, problematic aspects of the UNGPs, and especially as it relates to the tech sector that we are also grappling with. And this came to mind when Maristella was talking about combining several methods and spreading risks. The 4th approach that we use is the smart mix of regulation. So, for example, this is just an example. You could, in Indonesia, for example, you could use, or in Singapore, you could choose to use co-regulatory method, where more than 1 or 2 actors come together for regulatory purposes. And in some context, it is just a traditional approach, which is the state government that chooses to use their, traditional powers as the state to regulate, platforms. So we are looking at how, we can combine this method in a smart way to ensure that the overall goal is achieved, which is to, protect human rights at the end of the day. So, speaking more to core components of corporate responsibility, and in this context, human rights due diligence, There are 4 key steps to human rights due diligence. And as you can see on the screen, they include identifying and assessing impacts, to gauge the nature and extent of human rights risks. And at this particular stage, it is more like being the ability to be able to foresee the impact that a kind of product, for example, that's about to be rolled out by a private tech company could have on the people who might be using that kind of product. Secondly, is then taking efforts, acting to prevent and mitigate risks to people, including via integration within internal functions and processes. So this, for example, includes, and one example that comes to mind here is some of the internal processes that social media platforms have, when, for example, they're about to remove content and all of that. This speaks to some of these issues. And also tracking of effectiveness of risk mitigation responses over time. So it's not just enough to identify, risk. You need to understand and, be very alive to whether they are effective or not. So it is just not identifying mitigation or trying to mitigate risk for the sake of it. You need to be sure that this is effective as it is used. Then, lastly, is appropriate communication of performance with respect to addressing human rights impacts. So, also, it is not enough to, as a tech company or as a business, to say that you are addressing human rights challenges. You need to be able to show workings that you are able to do this, and communicate that also to the respective stakeholder. Importantly, the victims, for example, that are people that could have been victims of your business conduct. Yeah. So, moving on to the main gist, which is the UNGP's Compass tool. So the UNGP's, as you can see, this is a tool that it was as a result was developed to as a practical method to address some of the challenges that is faced, especially in technology governance. And just like the UNGPs itself, it went through several processes. Of course, it's not been launched yet, but it is getting towards the final stages. There were a series of consultations on the state duty to protect and regulatory approaches in line with the UNGPs targeting technology company conduct. You can see the timeline. There was also the launch of draft guidance tool for policymakers, this one targeting policymakers, the United Nations Business and Human Rights Forum in 2022 in Geneva. So that was in November 2022. Then current stage, it is currently being finalized. So I'll go into a bit more detail about the tool, but before I do that, let me focus on how the tool is relevant to the conversation being had. Now, if you look on the screen, you'll see that from the first row, there is regulatory implication with respect to platform governance, especially in sub-Saharan African context. And some of the problems that we've seen is that there's a fragmentation of existing standards on governance by states and platform companies. Like it has been mentioned earlier, companies have their community standards, states have their laws that they are trying to pass to ensure that platforms are brought in line. And this leads to quite a lot of challenges, including incoherence on applicable standards by right holders and duty bearers. It creates a kind of confusion, especially for right holders, especially on getting remedy for wrongs that have been done. And despite this incoherence, online harms continue to proliferate. It doesn't stop. It continues unabated, affects governance, affects democracies in ways unimaginable. And also, this also causes limited access to remedy, where people are still unaware, for example, when they've been faced with challenges, for example, the content was wrongly removed, or we've seen instances, for example, using Ethiopia as a context, where online, hate speech has led to offline violence. So and I know also there's a case currently ongoing against a social media platform in that regard. So, and we are beginning to see how actors, for example, victims of some of these harms, are getting more creative. Angela mentioned earlier on about a case against a social media platform in Kenya and in seeking access to remedy. So these are some of the ways how people are getting out of the typical formal community standards, waiting for community standards to take action, and actually taking action themselves. So we also see that, and I'm sure many in this room have experienced this before, when you're in the room with policymakers, and this is not to slight anyone, it is not a crime not to know, but most of the time, policymakers lack the time and resources to grasp the complexities of platform governance. Even many of us who have been working on platform governance for the longest time, we still grapple with some of these challenges, right? So, and it is usually due to many reasons, but I've highlighted two. It involves a complex web of actors, right? You deal with policymakers, social media companies, ISPs, civil society, technical standards organizations. All of these actors have their own interest, and rightly so. So how do you manage this? And how do you ensure that there's a consensus towards ensuring that human rights are protected? And also, I don't know if you heard, but if you've been in rooms with policymakers, they have this aversion for talking human rights standards. I don't know why, maybe we'll find out. But the fact still remains that because it is the universal nature of human rights, and the fact that it is not, there's nothing abstract about it, it's our everyday life, makes it very important that most of the standards must adhere to internationally agreed human rights standards, and also iterative stakeholder management. I'm going to speak more about the tool, especially on the iterative stakeholder management part. Then looking at this holistically is what now leads to the relevance and the importance of a tool that is broad enough to be able to speak to context, and which leads me to the second slide, next slide, on the aim of the tool itself. And the aim of the tool is to understand and hem core elements of the ENGPs in standards and regulations directed at technology companies. Before I move on, the fact remains that when you look at most laws that are supposed to target company conduct, especially in platform governance in Africa, you find out that most of them are overbroad, especially when you look at cybercrime legislations, and this is a very, very problematic area, even I know for government to surmount. And another key motivation for the tool is to enable businesses to enable responsible business conduct by placing the UNGPs at the core of choice of design and policy options and legal instruments, and also to foster protection for rights holders and provide clarity for business regarding the expectations of corporate respect for human rights in the technology sector. Now, to the compass. As you can see, it's a 4 steps as part of a cyclical process, and it is iterative. And it speaks to a broad but key step that every, whether it's businesses or policymakers, must pay attention to when it comes to coming up with policy design, policy development for platform governance, especially in sub-Saharan Africa. And I couldn't go into the guiding questions because it's a little bit deeper than this, but I just wanted to give an illustrative picture of what the compass looks like. So the first one is scoping and identifying the problem. I will apply it to I will show how it applies to platform governance much later. Scoping and identification of an objective. So what is the problem that we are trying to solve? Is it disinformation? Is it child sexual abuse material? Is it technology facilitated online-based violence? What exactly is the problem we're trying to solve? Then we move to the regulatory gap analysis. What are the existing regulations with respect to the problems? Do any exist? Do we need a regulation? And also then we move to identification of our venues for regulation. And I want to speak a little bit more about this. So, I mean, the earlier panel, I was listening to the speaker that sat to my left on the process in Nigeria. And I think one thing is very key, that because you have a hammer does not mean you must always see everything as a nail. So the fact that there's a problem with, online arms, disinformation, misinformation, or what have you, does not mean that specifically a law must definitely be passed, right? And if a law must be passed, there are different kinds of laws. There are soft laws and there are hard laws. The typical approach in most sub-Saharan African context is to use the hard law. What happened to soft law? Soft law, because they are soft, does not necessarily mean they are useless, right? There are very huge strengths to soft regulation. So these are some of the, context and issues that, the compass tries to address. Then also, in the design of whatever regulatory framework that is come up with, it is very key that enforcement, monitoring, and assessment is built into that, framework. So, and the goal of the compass is to align regulatory efforts on technology company conduct, with UNGPs. Yeah, this is a lot, but this speaks to the important design features from the UNGP's perspective, and they include the typical nature of the UNGPs itself. It has a very broad view of human rights. It doesn't speak to just freedom of expression alone, or the right to work alone, or the right to reproductive health or whatever. It speaks to the broad picture of what human rights, the human rights agenda is. Consistent application of human rights due diligence, the one I explained earlier. It must be applied throughout the value chain of the business conduct, not just at the beginning or in the middle or at the end, throughout. So accompanying measures such as incentive-based policy, also instruments and enforcement provisions, process-oriented character of the legislation relating to the expectations towards the business to meet, genuine stakeholder engagement. Most of the time, and I think this applies to not just state government alone, it also applies to businesses. Stakeholder engagement is not a box-ticking exercise. It needs to, when you engage with stakeholders, you need to show how exactly you've applied whatever it is the consultation process resulted in. Did you utilize the process? If you didn't, why didn't you, and what did you use instead? So these are some of the key questions and the design features from the UNGPs that that the compass tries to look into. And also there should be clear provisions, and not just clear provisions, clear procedures on access to remedy, because it is not enough to have provisions, because you're dealing with a large context, and different context at that. Procedures must be clear on how to seek and get remedy. And this is the application of the UNGP's compass tool to the conversation being had. So, in the wheel, we had spoken about identifying the problem, for example, the impact of online harms on human rights. And even at this is too broad, because what kind of online harms are we speaking about, right? And it speaks to what the media representative has said earlier about omnibus laws in the region where you have themes being regulated under one law. That creates quite a lot of challenges, especially when it comes to enforcement. And after identifying what the problem is,
just to keep you track of time.
Yeah, this is the last slide. Yeah. So there is need for coherence of existing regulations on right-based approach to platform governance. I know that it's difficult to form consensus on the kind of regulation or how to even arrive at that regulation. But the fact remains that when we are facing the hard challenge of platform governance in Africa, some laws will need to go. While some will need to go, some will need to be amended. And where stakeholders agree, some will need to be enacted. So these are some of the tough questions that, that speaks to policy reform that aligns with UNGPs, especially by duty bearers, and in this context, states. And also, smart mix of regulatory consensus to address online harms. So it's not just about self-regulation, what also are the interests of the states, and how do we merge that together, especially also considering the kind of work that civil society has done with respect to platform governance in general. Then also ensuring multi-stakeholder-driven enforcement of human rights due diligence processes. Then importantly, there needs to be tailored engagement with policymakers that address the complexities of governance, platform governance. And I use policymakers here a little bit loosely, and I don't mean just parliamentarians. I mean the judges, the cybercrime section of our police forces, the military. You can go as broad as possible. The people who form and make policy needs to understand what the nitty-gritty of platform governance is and what the issues are, so they are well informed on how to regulate. You can't properly regulate what you don't understand. And lastly, step-by-step application of the UNGP's compass to platform governance includes stakeholder engagement, rule-making, enforcement, and monitoring. I think I'm going to end there so I can give my other panelists the opportunity to engage. Thank you very much.
Thank you, Tomiwa, for the very comprehensive overview. I think that we're going to have a lot of time for discussion further along in the session too. I'm not sure we'll have too much for questions for this panel because we have some virtual ones joining that I want to ensure for the next one. But the OHCHR and VTech are not the only people at the UN working on this issue, of course. So I think it's a good segue now to look over to Anna. And Anna, at UNESCO, I know that you're working on the issues of platform governance. The guidelines have come out. So can you tell me a bit about that, the work that you're doing, and really how you see it playing a role in this space? Thank you.
Thank you very much. Hello everyone, bonjour à tous. I'm Ana Cristina Ruelas, Senior Program Specialist at the Freedom of Expression and Safety of Journalists section in UNESCO headquarters. And I'm leading the work on freedom of expression in the digital environment. So as you all know, UNESCO started a process after the release of the Rome Principles that says that any kind of discussion related to internet governance should be right-respecting, open, multi-stakeholder. And UNESCO, after that, realized that there was a lot of discussions about how to deal with content that could be permissibly restricted under international human rights standards, specifically cases of hate speech or disinformation that is spread in a systematic way, in balancing, safeguarding freedom of expression and access to information. So this discussion started in 2022. We went to a consultation process that led to the engagement of people from around 134 countries. and many of you participated. Actually, if I say 54% of the consultation, of the comments from the consultation came from the African countries of regulating JET. So the guidelines at the end ended up as a document, an instrument, that tries to guide member states in their process of governance of digital platforms, specifically focus, and I have to say this, in the governing of content that could be permissibly restricted under international human rights standards, meaning Article 19.3 of the ICCPR or Article 20 of the ICCPR. So we don't go beyond markets, we don't go on competition, we don't go on data, on privacy. It's to go all together into one specific piece. And it's actually not true, because right now there's many, many regulations that already deal with digital platforms. For instance, in elections. Elections has been a regulation that has been in the offline world for many, many years. And now they're touching topics on digital platform governance. And what these guidelines say is that when it comes to content that relates to electoral integrity, to provide electoral integrity, we need to read through the rest of the guidelines in order to have a human rights-based approach and a multi-stakeholder approach. The guidelines are not an element just to create new laws or to create new institutions, but to be able to read the different legislations or the different regulations that are out there in order to see it through these lenses. And we also believe that these guidelines need to work in a comprehensive manner with other forms of regulation, other regulatory arrangements. As we know, there's many other regulatory arrangements that right now deal with platform governance. There's some of them that have been mentioned, and actually in the last session we mentioned, for instance, the Oversight Board as a self-regulatory measure that enables people to connect with other statutory regulations that need to be, let's say, work together in a comprehensive manner. In many of other countries, for instance, here in South Africa, we have a very strong media councils that actually participated directly in the guidelines that were mentioned for the electoral processes, and they are trying to connect their work with statutory regulation, with other forms of regulation, in order to create a more coherent approach of platform governance. This is important in terms of the guidelines, because what we aim is not to think that one thing is going to solve the problems that we see in the digital sphere. We need to have a comprehensive and integral view of the problem, and as well to approach like that in the solution. So the guidelines aim, as simple as it is to safeguard freedom of expression and access to information while dealing with the governance of digital platforms, specifically on content that could be permissibly restricted under international human rights standards. For us, what is very important is to maintain this balance, which is very difficult, as it's been said. And in order to maintain this balance, what UNESCO is saying is that there's specific responsibilities for different stakeholder groups that need to be upheld. So, for instance, the governments need to enable the environment for freedom of expression. And this sounds very easily, but when it comes to digital platforms, there's specific rules that governments have to follow in order to make sure that they are enabling the environment. The first thing that we are always saying is that governments need to be transparent about the responsibilities they uphold upon digital platforms. They need to be transparent about the removal request or anything that they are asking to digital platforms. They also need to be able to refrain to any kind of criminalization of digital platforms when they do not perform what they want to do, so they don't create a chilling effect. And I will, because there's a huge list that you could go and see in the guidelines. And the third one is that in any case, there's no possibility, will never be proportional to take a shutdown mechanism. These three, I'm just saying, comes from a list of like 30 other responsibilities, but I will focus on that because I don't want to take that much of a question time. Then the second part is the responsibility of digital platforms. And then the responsibility of the digital platforms, they communicate a lot with, it's been said yet already by my colleague. One of the things that we say is that first, platforms have to make sure they have systems and processes established in order to assess human rights risks, to prevent and to mitigate, to prevent and to respond to those risks. But doing risk assessment, they just do it at one moment, or for instance, in elections for 70 countries or for 54 countries. We want them to be able to do specific human rights impact assessment in different moments and according to the different users that they are dealing and that are facing different risks. Because as you all know, the risks that, for instance, journalists are facing in the digital platforms are not the same risks that women are facing in the digital platforms. So we need to take specific measures, and we need to be able to acknowledge those kinds of risks and how the products, services, advertising mechanisms are impacting these people. We need to make sure that when they release new products, they have specific mechanisms to mitigate the risks to different to specific groups, but also in a specific context. So the UNESCO guidelines say that there are specific moments, particularly, that the platform should make specific risk assessments. So, for instance, reviews during the electoral cycle, not only previous electoral cycle, but during the electoral cycle in order to identify potential emerging risks. During conflicts and crises, which means not only, for instance, armed conflicts, but also protests, catastrophes, emergencies that are happening around. And when there's a specific change on the product services, so for instance, ownership, new designs, etc. So this is the first principle. For us in UNESCO, we want to stress all the time that these guidelines are a system-based, have a system-based approach, which means that we don't think that by regulating specific pieces of content, we are going to deal with the problem. As is being said, the UN guiding principles are very clear that when it comes to specific pieces of content, you have to go through a due process of law. But when it comes to systems and process, platforms must be accountable about those systems and processes, about how they are dealing and identifying this risk and what are the type of measures that are put in place in order to move forward. There are some platforms that are already doing this in some way or another, not for all of the countries, I must say, but there's some specific cases that we can highlight. Then the second principle is relates to transparency, that retrieve a lot of what the Santa Clara principles, and it's transparency not only about how they implement their community guidelines, but also related to how they manage their algorithms in their advertising. How the external evaluation of those AI systems can be released, about access to data, about many other things. Also, a long list in the guidelines, I will not repeat them all. Then the third principle relates to accountability, which relates a lot to how the platforms create these mechanisms for the users to complain and to actually do it in their own language. Because in some cases, what we have seen, or what we received during the consultation process, is that even though there's complaint mechanisms, there's two problems. One, complaint mechanisms not always work in the language or considering the context of the different countries. And the second one is that when there's new products that are released, for instance, right now with the Gen AI, new features in the different platforms, they don't really come with redress mechanisms. So they release them, they deploy them, and then boom, there's the problem. So the idea of accountability is to be accountable from the beginning, to have the possibility for the users to complain and to redress in their own language, and that complaints mechanisms are able have the possibility to be responded considering the user, considering the language of the user. The fourth principle is aligning their operations to international human rights standards. So I'm not going to go very deep on that because international human rights standards, we are aligning to the UN guiding principles for international human rights and a lot of what the BTEC project does. So it's pretty much following what has been said. And then the fifth principle relates to provide tools for users to have control over their own content and over their participation in the digital civic space, which means not only, and we don't want companies to uphold the responsibility to create programs on media and information literacy, but we do want within the governance system that they had the responsibility to provide the tools for users to have control over the data, over the content that they're receiving, and to have the possibility to engage critically with them. So these are pretty much the guidelines. And now they were released in November last year, and now we're in a stage where we want to first get people know the guidelines and see what they entail, what is it there. But on the other side, we want to make the word multi-stakeholderism something meaningful. Because we say that it is everywhere, but what we realize over and over again is that the silos remain, that the discussions keep being separated, and that is more necessary than ever to bring together the different stakeholder groups. So having here a person representing the audiovisual authority for us is very important, because it brings the opportunity for those that are implementing these regulations with this new hat that is being given to them to have the possibility to engage with all of us and to try to bring different discussions. So UNESCO is working right now in the development of the Global Forum on facilitating the strengthening of the Global Forum of Networks, which is a group of regulatory authorities that are now with this new task of dealing with digital platform governance, and that are trying to do it in a commonly way, because they have a lot of challenges. I'm sure that here there's going to be a discussion on this, but we had a conference in June, and we realized I'm going to speak about, let's say, the 4 main challenges that we saw. And everything comes to the word asymmetry. There's asymmetry on knowledge and capacity between the different regulatory authorities all across the world, between, for instance, Western African regulators, between Eastern Africa regulators, Southern, there's different levels of knowledge, and it is normal, because there's a lot of, as you mentioned, not all of us are experts on everything. We are always learning. We're on the process of learning, and this is one of the things. There's many regulatory authorities in some countries that are already dealing with a specific regulation, for instance, in the European Union, that they are already implementing, that they are already seeing the results, etc. And there's other ones that are just exploring how it's going to work. So this asymmetry is important and needs and creates certain gaps. The other asymmetry relates to engagement. So digital regulatory authorities, there's regulatory authorities that have at least 7 people from each company to engage with them. And there's other one that have never seen in their life one person from one of the platforms. So this is a huge gap that creates a lot of problems, because what happens is that while there's no, let's say, communication mechanism between the regulator and the platforms, then it creates a lot of problems around the process of regulating. So this is another asymmetry. Then the other one comes to metrics. So while there's some regulators that ask for some things, or some transparency metrics to some kind of platforms, then there's other regulators that ask for other things. And to be honest, sometimes what happens with this asymmetry and this fragmented system is that at the end, there's no common ground where the companies can comply on this transparency metrics. So there are some of them that comply more or less with the ones that says in the Digital Service Acts in the European Union, but they don't exactly do the same thing for other countries that are asking other things. So this is creating another problem. And the other thing is that, and there's another problem that they mentioned, is that even though we all talk about multi-stakeholderism is expensive. It requires budget. It requires having the capacity to read the inputs for the other people. If not, it becomes cosmetic. it requires the need, like the capacity to host the people in the place where you're bringing them together. So that's a huge challenge of making this discussion multi-stakeholder. So this is another challenge that they mentioned. And they also mentioned the challenge of, making sure that that the media and information literacy programs are actually, like thinking on the last one, multi-stakeholder, that media and information literacy programs always come cross-cutting with the needs of those that mostly need it, like the users that are going to be the target, and involving other type of content creators, not only, let's say digital platforms, but new content creators such as influencers or media outlets.
And just a quick
Okay, so that's it. No, I'm going to wrap up. So the Global Forum of Networks right now is one of the main, let's say, we want this forum to work. We want them to engage with the different stakeholders. The different regulatory authorities, including the REFRAM, is very much engaged. The ACRAN also is very much engaged. They have already gone very far away from other regions, which is very important for the African region because they really are upholding and they're coming together in order to face common challenges, but also to create a force that will enable them to engage in a better way with the digital platforms. That's it, and thank you very much.
Amazing. Thank you. Thank you, Anna, for covering the work of UNESCO and the guidelines and providing another perfect segue in terms of speaking about regulators. So, Mr. Matalsal, I think we've discussed now a number of the international standards and guidance, ones that have been recently developed and about to be implemented. And I'm curious from your perspective, because you're from the Conseil National de Régulation de l'Audiovisuel, how do we see this in practice, and what are the challenges? How does this relate to your work? And if I can kindly ask you to keep your comments as brief as possible, but not too brief. I don't want to be rude, just so we can keep the time. Thank you so much.
Merci Yann. Bonjour à tout le monde. Yann peut-être commencer par dire que c'est un plaisir. On faisait des échanges par Internet seulement. C'est aujourd'hui qu'on se rencontre. Je pense aussi dans les échanges, il y avait parfois Ophélie, je ne sais pas si elle est dans la salle, Marjorie aussi. Donc là, vraiment, c'est pour dire que ce fut un plaisir pour nous de décider de participer à cette importante activité, n'est-ce pas? Donc, véritablement, qui concerne et les plateformes numériques, mais également les organes de régulation. Moi, je suis Matar Sall, je suis juriste de formation, enseignant. J'ai été membre du collège du CNRA. CNRA, c'est l'organe de régulation au Sénégal. Je suis actuellement le directeur des affaires juridiques de cette institution, tout comme le directeur de cabinet du président du CNRA. Parlant de régulation, il faut dire que vraiment, c'est surtout ensemble qu'on envisage cela. Donc là, c'est la raison pour laquelle, effectivement, dans la régulation, on a constitué des réseaux, différents réseaux, n'est-ce pas, d'organes de régulation. Ce sont ces différents réseaux qui permettent de prendre en charge la question de la régulation des plateformes numériques. N'est-ce pas? Maintenant, dans la régulation des plateformes numériques, effectivement, donc là, les organes de régulation, ils vont de manière concertée. Tout comme, donc là, véritablement, il faut dire qu'il y a les organes de régulation, en tout cas au niveau africain, cherchent toujours à avoir une collaboration avec les plateformes numériques. Donc là, il y a eu vraiment une dizaine de rencontres qui concernent donc la régulation des plateformes numériques. À certaines de ces rencontres, il y a les plateformes numériques qui étaient présentes, n'est-ce pas? Par exemple, il y avait sur... Traduction. OK. C'est bon? Ok. On peut reprendre?
I think we should continue. I'm sorry, just for timing. Vous pouvez continuer.
Je peux continuer. Voilà, merci beaucoup. Parlant de la régulation, n'est-ce pas? Donc là, il ne faut jamais commencer par entendre, chaque fois qu'on parle de régulation, entendre par exemple restriction, n'est-ce pas? Donc là, parfois donc les non-régulateurs ou bien ceux qui ne sont pas dans le domaine de la régulation, chaque fois qu'ils entendent parler de régulation, ils pensent donc vraiment à des restrictions, à des obstacles dans le travail de tel ou tel autre acteur, n'est-ce pas? Donc là, si on parle de régulation des plateformes numériques, n'est-ce pas, véritablement c'est toujours sur la base donc de la réglementation. D'ailleurs, je dirais que les organes de régulation sont autant tenus de respecter la réglementation que n'importe quel autre acteur, n'est-ce pas? Donc ce qui fait que vraiment leur action se fait dans le cadre de la réglementation. Dans la réglementation, d'ailleurs, pour montrer que vraiment, encore une fois, les standards seront respectés internationaux. Exemple, ici, il est dit préserver la liberté d'expression et l'accès à l'information. Je dirais que la première des missions pour les organes de régulation, c'est de respecter la liberté d'expression. N'est-ce pas? Dans les lois qui créent les organes de régulation, il est clairement dit que les organes de régulation veillent au respect de la liberté de communication et d'information. Donc, ce qui fait que vraiment, encore une fois, l'organe de régulation ne peut pas venir et dire je vais constituer un obstacle au libre exercice de la liberté d'expression. Mais l'organe de régulation, bien que tenu de respecter la liberté d'expression, est également donc véritablement doté d'une prérogative qui consiste à protéger la société, notamment donc vraiment dans les contenus diffusés. Par exemple, on joue un rôle de protecteur de la société. Par exemple, s'il y a des discours de haine qui sont diffusés, exemple, s'il y a donc vraiment des contenus qui portent atteinte à la dignité humaine, on n'est plus dans la liberté d'expression parce qu'on est dans les abus et par conséquent, l'organe de régulation pourrait intervenir, n'est-ce pas, vis-à-vis donc des plateformes ou bien donc les médias audiovisuels. Parlant maintenant des organes de régulation, surtout les plateformes numériques, la régulation des plateformes numériques, je dirais que ce n'est pas individuellement, en tout cas au niveau africain, on a su que ce n'est pas individuellement qu'on pourra faire face donc véritablement aux plateformes numériques. C'est-à-dire, donc là, il ne faut pas penser à une régulation pays par pays. N'est-ce pas? Donc, il faut plutôt aller vers des réseaux. Donc là, c'est la raison pour laquelle, effectivement, il y a plusieurs réseaux. Par exemple, le CNRA est dans 3 réseaux. Le REFRAM, c'est le réseau, n'est-ce pas, des organes de régulation francophones. C'est-à-dire que tous les pays francophones sont dans le REFRAM. Il y a le RIARC, c'est le réseau qui regroupe l'ensemble des instances de régulation du continent africain. Ensuite, il y a ce qu'on appelle la plateforme des régulateurs de l'audiovisuel des pays membres de l'UEMOA et de la Guinée. Parce que le Sénégal fait partie des pays de l'UEMOA. N'est-ce pas? Les pays de l'UEMOA ont constitué une plateforme. D'ailleurs, laquelle plateforme même a signer un accord de collaboration avec la commission de l'UEMOA. N'est-ce pas? Donc là, on est véritablement entre la plateforme et la commission de l'UEMOA, il y a un accord de collaboration. C'est la raison pour laquelle, à toutes les rencontres, par exemple, de la plateforme, la commission de l'UEMOA a un représentant. Parce que dans l'accord de collaboration, il est dit cela. Donc c'est pour dire que vraiment, c'est un réseau que les organes de régulation vont essayer de faire, donc véritablement dans la régulation des plateformes numériques, mais toujours selon donc un principe très important, la transparence. N'est-ce pas? Donc là, d'ailleurs, par exemple, c'est parce que c'est transparent que dans les différentes rencontres sur la régulation des plateformes numériques, on invite les plateformes numériques. Donc il n'y a rien de caché, il n'y a pas donc véritablement de volonté de restriction, bien au contraire, donc là, à certaines des rencontres, il y a les plateformes numériques qui assistent du début à la fin. Il n'y a pas de huis clos pour dire on va par exemple en aparté voir quelles contraintes donc vraiment ériger ou bien quel obstacle ériger pour ne pas permettre aux plateformes numériques d'exercer librement leur travail. Donc là, il y a eu une dizaine de rencontres donc des différents réseaux, n'est-ce pas, le REFRAM, le RIARC, la plateforme, n'est-ce pas, donc qui concerne la régulation des plateformes numériques, n'est-ce pas. Donc là, et ces rencontres ont toujours insisté sur véritablement la nécessité d'aller vers une approche inclusive de tous, y compris des plateformes numériques, les organisations de la société civile. Ça, parce qu'encore une fois, les plateformes numériques, ça ne concerne pas seulement les plateformes, ça ne concerne pas seulement les régulateurs, ça concerne tout le monde. Parce que véritablement, c'est quelque chose qui est utile pour toute la communauté. C'est la raison pour laquelle, à certaines rencontres même, la société civile également, donc véritablement, est conviée. Et donc là, les experts et autres, donc là, on va essayer de voir quel mécanisme, quelle stratégie la plus adaptée pour réguler les plateformes numériques. Donc là, avec l'objectif bien clair dès le début, qui consiste à dire ce n'est pas pour constituer un problème dans le fonctionnement. D'ailleurs, c'est la raison pour laquelle même parmi les recommandations souvent, c'est toujours, on recommande aux États de confier la régulation des plateformes numériques aux organes de régulation. Parce que les organes de régulation sont indépendants. Donc là, il est préférable de voir les organes de régulation indépendants réguler la plateforme numérique que de voir, par exemple, le gouvernement le faire. Parce que donc là, le gouvernement, donc là, vraiment, ils n'ont pas de statut d'autorité administrative indépendante. Ce qui fait que, par exemple, un ministre peut tout de suite décider, par exemple, de faire des restrictions sur TikTok ou bien sur Meta et autres. Alors que pour l'organe de régulation, donc véritablement, ça se fera dans le respect toujours de la réglementation. Donc ce qui fait que, vraiment, encore une fois, de ce point de vue, les organes de régulation sont très conscients de l'importance. Par exemple aussi pour montrer que c'est toujours en réseau qu'on veut agir, c'est-à-dire les différents organes de régulation. Au niveau de l'UEMOA, il est envisagé l'adoption d'un règlement. Parce qu'effectivement ici on est dans le cadre communautaire. L'adoption d'un règlement, lequel règlement, donc là vraiment encore une fois, sera un texte pour l'ensemble des 8 pays, plus peut-être si la Guinée est d'accord, parce que la Guinée n'est pas membre de l'UEMOA, mais quand même la Guinée est dans la plateforme. Donc là, avec ce règlement, on pourrait véritablement décider, ou bien on pourrait retenir comment réguler les plateformes numériques. N'est-ce pas, en attendant par exemple de l'avoir à une étendue plus large, c'est-à-dire pourquoi pas au niveau continental, par exemple à travers le RIARC. Exemple, je pense qu'il y avait le président de la ACA de Côte d'Ivoire, je pense qu'il a fait le déplacement, il est là. Je pense, donc dans un mois, il va organiser une rencontre à Abidjan dans le cadre du RIARC. N'est-ce pas? Donc là, et on va toujours aborder de ces questions. N'est-ce pas? Et surtout, avec le cadre réglementaire, par exemple, un règlement au niveau de l'UEMOA. D'ailleurs, donc là, la commission de l'UEMOA avait, parce que dans le cadre de l'accord, il est toujours dit que vraiment, encore une fois, ensemble, nous allons travailler, nous allons collaborer. Et la plateforme des régulateurs de l'audiovisuel a ce qu'on appelle le comité des juristes experts en régulation des médias et en TIC. N'est-ce pas? Donc là, lors d'une des rencontres, la commission de l'UEMOA avait dit au comité de préparer un avant-projet de règlement. N'est-ce pas? Donc là, qui permettrait vraiment, encore une fois, de prendre en charge la régulation. Mais je dirais toujours que la régulation n'a pas pour objectif donc vraiment de constituer un blocage dans le fonctionnement des plateformes numériques. Bien au contraire, la régulation donc, va aider les plateformes numériques, par exemple. Pourquoi pas, donc là, à travers la collaboration, voir comment régler, comment gérer ensemble certaines questions, certaines préoccupations. Peut-être, je vais terminer en disant que souvent, ce sont les régulateurs qui invitent les plateformes numériques dans leurs différentes rencontres. Je pense qu'il faut aussi que les plateformes numériques envisagent, parce qu'ils savent que dans tous les cas, il y aura une régulation, il y aura quelque part quelqu'un qui va veiller sur ce qu'ils font. N'est-ce pas? Donc là, et par exemple, les plateformes numériques aussi pourraient penser à, parfois, chaque fois qu'on parle de régulation, parce que dans la régulation, il y a l'autorégulation déjà avec eux, à travers donc la modération et autres, mais penser à tenir des activités aussi avec les organes de régulation, n'est-ce pas, notamment en passant par les différents réseaux que vous connaissez déjà. Par exemple, au niveau européen, il y en a, en Afrique, il y en a, et donc vraiment dans la sous-région, il y en a. Je vous remercie, monsieur. Je pense qu'on ne veut pas être trop long. Merci encore.
Thank you so much for your comments, and also I think pushing for transparency, the actions you're taking in a coherent effort, and it kind of wraps up a lot of the points and a lot of the things that I've been observing for this panel, which is that standards and guidance, but we truly do need to operationalize them in a way that's effective and coordinated, that involves doing so in a multi-stakeholder effort, doing it also in a way that considers context and its implementation, which is clear. So I want to thank all of these panelists today. I think we're going to pause for questions until the end of the final roundtable, which we're going to start in just a minute because we have some online speakers that have time restrictions. But thank you so much, and we'll continue the conversation. Maybe just take 5 minutes so we can get set up for the next panel. Would be great. Thanks, everyone.
Thank you. I guess they will meet us right as we go on. So to start, we are moving to the third mini roundtable, which we're already late for, and the title of the roundtable, mini roundtable, is Multi-Stakeholder Collaboration and Best Practices in Platform Governance. And again, my name is Tomoa Ilori, and I will from OHCHR, and I will be moderating this particular roundtable. And I also want to warmly welcome our speakers, Commissaire Willie from Vodacom, Montserrat Legoreta from Global Network Initiative, Adeboye Adegoke from Paradigm Initiative, and Gayatri Kandahadai from Business and Human Rights Resource Center. To start with, I'm going to start with Nkomsa. Please let me know if that's fine with you. Can you hear me?
Yes, I can hear you.
Thank you very much. To start with, I would like to ask you, and like I've joked with my co-panelist here, I'm a dictator when it comes to moderation. So please, you have 5 minutes to answer this question. So the question is, what are the best practices that companies are implementing in platform governance on human rights, and how are they reflected in their provision of services in sub-Saharan Africa? Thank you very much, Nkomsa. Over to you.
Thank you so much. Please allow me to begin by just reiterating that my name is Sawini, and I work for Vodacom Group, where I am the human rights specialist, senior specialist, where I obviously work in terms of ensuring that we integrate human rights principles into our everyday activities and ensure that we respect human rights as an entire. Toriwe, I think your question is a very pertinent question, but I think I will respond to this question by saying that as businesses in the digital era, particularly in platform, we need to adopt a company-wide human rights approach that is in line with international human rights standards and principles. And we need to align our governance frameworks with these internationally recognized human rights principles. And one of the best practices is to ensure that the company-wide human rights approach is in line with the NGPs, which is the United Nations Guiding Principles on Business and Human Rights, and also in OECD and other regional frameworks that are applicable. You then need to have a specific human rights policy. That's one of the practices that we use, to have a specific human rights policy that governs how we respect and how we promote human rights within our businesses. And this policy is generally publicly communicated to ensure that our human rights commitments are well understood by all our stakeholders, and also that our stakeholders have the opportunity to hold us accountable to what we commit ourselves to. So it helps us with the check and the balance. In drafting this human rights policy, we generally use to involve multiple stakeholders. So we will involve
I think we lost Nkomsa briefly there. For the sake of our time, I'm sure she'll take off from where she left. Let me move quickly to Montserrat, if that's fine. Thank you. My question to you is, what would you call the best practices that companies are implementing in platform governance on human rights? And how are they reflected in their provision
of, oh, sorry, I think there's a mix-up there. Give me a second. Are you sure? Was it? Okay. Okay. What are the best practices that companies are implementing on platform governance on human rights? And how are they reflected in the provision of services in sub-Saharan Africa? Yeah.
Thank you so much. My name is Montserrat Legorreta, but you can call me Monse because sometimes it's a handful. I'll keep it to 5 minutes, my extend to 7. I hope that's not an issue, just up front. So I'll speak, I'm a Membership and Program Associate at the Global Network Initiative. So for those of you who may not be familiar, I'll just do a quick overview of what we are. We are a multi-stakeholder organization that focuses on freedom of expression and privacy. And we have 4 different types of members. We have companies within our fold. We have civil society organizations, academics, and investors. And really, some of our previous panelists have talked about self-regulation, and the Global Network Initiative was actually born in 2008 as a self-regulatory measure with overbroad requests from governments for data. So companies came together and said, how can we actually respond to this? This is an issue. And so that is how this is how the Global Network Initiative was born, but really through a multi-stakeholder model. So that's really important. We have to remember that in 2008, the internet looked completely different to what it looks like today. Some big companies weren't as big as they are, and also social media maybe perhaps wasn't what it is today. So that's important to note. So really the evolution of technology and these platforms is something to keep in mind. With that, I'd like to say that, and I think this is the definition. I think Numisa's back? Or just hearing my own voice? That's my voice. Okay, I'm sorry. I'm mildly embarrassed about hearing my own voice. But I will continue now. And so I think this is the approach that's been kind of talked about around platform governance. Platform, at least in the GNI and how GNI thinks of it, is a system, a technology ecosystem-wide approach. This is because our company members are everything from the equipment providers, so things like companies like Ericsson, to internet service providers like the telecommunications companies, to cloud service providers like Cloudflare, to the platforms where you see the content like Meta and Google. So it's really the ecosystem in general that we're talking about when we talk about platform regulation, not just the content, which is something that we understand a lot of people like to focus on, but really human rights need to be respected across the tech ecosystem for approaches to be effective. So I think that's the first thing that is really important to note. And when I speak, and that's what I mean by, that's what we mean by platform governance. And so really the Global Network Initiative holds companies accountable to the GNI principles, which were mentioned by my colleague at Meta. And really those were based and drafted around the same time as the United Nations Guiding Principles on Business and Human Rights, which you've heard about already. Really where the state's duty is to protect, corporate responsibility is to respect, and also provide remedies. So those 3 things are embedded into the GNI principles on privacy and freedom of expression, alongside their implementation guidelines. So this is a handful, but really what it means is that if a company becomes a member of GNI, they make a commitment to abide by these principles with good faith efforts with improvement over time. So they agree to be assessed every 2 to 3 years, and it's a voluntary assessment, but really, as we've seen now, a lot of like what we do from a voluntary is now being baked into hard law So it's our assessment continues to be a very good metric to really push companies forward and provide them with guidelines in which to respond to government. Some of those are some really good practices, and we encourage companies to kind of come into the GNI fold because it's more than just the assessment, right? That's the accountability pillar. We also work on policy, so we respond to policy developments in real time, but we provide a learning space where civil society, academics, investors, and companies can come together and discuss issues in a confidential setting that really allows the conversation to move forward. So this is a truly multi-stakeholder effort. So I think in answering your question, that's something important. To answer the question on the, specifically in Africa, we would really love more companies in the region to join. Right now, MTN is a member, and I guess I get 60 seconds. I'm just being told here. The last thing that I will also say is, like, I was going to go through the 4-step process that actually Meta outlined through our public assessment report, where we actually have specific case studies about how companies like Meta reacted to demands for data or shutdowns. Like, those are the two things that, well, some of the things that we talk about in another case study that is orange, but maybe in the questions, if you want to ask me, I am more than happy to go into it. But it's a really, these case studies kind of outline how telcos like Orange responded to a moment where they were asked to either slow down Facebook and Twitter or filter traffic, and using human rights principles in order to do this. And then the case study also, which you can find in our public assessment report around the Uganda case, where content was reviewed, and that was already outlined by my colleague at Meta really well, and she also spoke to the GNI principles and guidelines. So I'm happy to go through that also step by step, and it's on our website. So those are a few things that I wanted to highlight, and I'll pass it back to our moderator.
Thank you very much, Montserrat. And back to you, Nkomsa. Can you hear me?
Yes, I can hear you. Thank you so much.
Yes, please go on.
My apologies that I had network issues, ironically. So I think where I was saying that there needs to be obviously a human rights policy that is established, and that the human rights policy needs to be drafted and established in collaboration with multiple stakeholders. These include obviously your affected individuals. This includes your NGOs that work particularly with these human rights issues. This also includes your national human rights institutions in your various country of operation, and also your regional and international bodies such as your UNICEF. And also the opportunity that exists is that we can be able to leverage peer-to-peer review and peer-to-peer learning. So you have within the telecom space companies that are a little bit more ahead of others in terms of the human rights journey, and you can collaborate with them to ensure that you learn best practices for them and that you are able to implement these best practices. You also then need to commit to a due diligence approach so that you are able to assess your human rights impact of the services and where you operate and how you are implicated in any human rights violations. Your due diligence approach needs to, one, insist of a proactive risk-based scanning, where you are able to look at what you're proactively scanning to see what are your human rights impacts, what are the key human rights risks that you might have by virtue of the services that you are providing and where you are operating. But then there's also a reactive one, where in instances, say for instance, you have received government requests for user data, or a request to shut down the internet, etc. Here you need to have it's a reactive, but it's based on your previous due diligence of assessing and knowing what your environment looks like. You'd be better prepared to respond to these kinds of crisis issues. So here we're looking at having a crisis management or incident management practice that sets out clear guidelines on how you manage these types of requests based on human rights principles, and also based on your human rights policy, etc. You also then need to have a post-crisis management solution where you are able to track and trace how you responded. You are able to offer remedies if there were any human rights violations, to monitor the effectiveness of your remedies, and also go back to the affected individuals to ensure that the remedies were effective, etc. And I know that this is a little bit of an issue because we are afraid of legal liability, but unfortunately, remedies are an important part of how you manage and how you respect human rights within the business in which we operate in. You also need to build relationships.
Nkomsa, sorry, you have 60 more seconds. Thank you.
All right, thank you so much. I think in 60 seconds, all I would say is the United Guidelines on Business and Human Rights become your core tool that you need to use. You then need to learn and be able to collaborate and work with other stakeholders, because it really is a task that will take an entire village to be able to implement. And I also think what needs to be done is be transparent and honest about where you are in your human rights journey. This way you'll be able to be given the support that you need, and that you'll also be able to build relationships with the key stakeholders that are needed in order for you to really implement your human rights approach in a way that is effective and in a way that protects human rights. Thank you.
Thank you very much, Nkomsa, for your presentation. That's quite illuminating, and that takes me next to the next speaker. Adeboye, you've had Nkomsa speak about what Vodacom, for example, is doing with respect to their human rights obligations, and based on that, I would also like to ask you a question. How can private companies collaborate more effectively with civil society to advance business respect for human rights? 5 minutes. Thank you.
All right, thank you very much for your question. I'll address the question under 4 points, hopefully within 5 minutes, 1 minute per point. So I think, and I'm going to speak from experience. We've heard a lot today about what guidelines are out there, right, in terms of compliance with human rights standards and all of that. But in terms of civil society collaboration, I think the first point I want to make is that private companies must respect the independence of civil society for effective collaboration. And what do I mean by this? I think that within the context of platform governance and the role of civil society, I think civil society has an important role to play in terms of holding platforms accountable. But I also understand nuances around the relationship that platforms have been able to successfully build with civil society, which in one way might even incapacitate civil society from performing that, watchdog role. But I think the way this can work is by, showing more respect to the independence of civil society. And what do I mean by this? Many of us are friends with platforms. Our friends work in most of those private companies, in most of the tech companies and all of that. In fact, a lot of our friends who used to be in civil society now work there. So it makes it difficult to hold platform accountable. But when I talk about respect for independence, is when we understand that we can be friends, but when we need to call ourselves out, we should call ourselves out. I've shared this story with some of the colleagues in this room when I was speaking at a webinar some time ago in Global Start webinars on platform accountability, and I was speaking specifically to Meta, and a friend of mine who works in Meta, I was still speaking and I saw a message pop up on my phone, like, really, you are talking about us, So, and I said, we need to respect the fact that civil society has a watchdog responsibility. So our relationship does not matter. If I think that there are harms on Meta's platform that is not being that is not being addressed as it should be, I should be free to talk about it without thinking that my friends in Meta will get offended. So that's just an example. So that need to respect independence must really be there. Also collaboration. I think that there are so many opportunities for collaboration between platforms and civil society organizations. So for example, most platform and private organizations, they are usually ahead of governments in terms of even addressing human rights concern and harms on their platform. So they come up with internal policies and all of that. But I think there is usually challenges around socializing those policies. So an average man on the street doesn't understand the policy. And this is where collaboration with civil society can come in. If platforms work more, if tech companies work more with civil society to kind of help socialize their guidelines, some of the safety procedures and the human rights that they have enacted or they have put in place, it's really going to help in terms of making more people aware and also make those effective in terms of real implementation. I think the third point I have here is transparency. Most tech companies have transparency reports, also in compliance with the UN guiding principle on business and human rights. But a lot of people are not even aware of this transparency report. So beyond ticking the box, fulfilling the requirement of publishing transparency reports, I think there also needs to be, follow-up engagements with relevant stakeholders like civil society to kind of share those reports with them, to kind of also just tying into the points I made earlier about socializing what private companies are doing to kind of help to see opportunities that exist in that transparency report. Because what transparency report does is that it also gives civil society an insight into what platform governance looks like in their jurisdiction, what their government is doing, and to be able to also assess that from the perspective of human rights compliance. And lastly, I'm going to talk about the role of civil society as watchdogs. I think there can be collaboration in terms of civil society helping to see to what extent the guidelines that private companies have come with, to what extent do they comply with guiding principles, international best practices, and all of that, and also providing independent reports. So it is one thing for platform to say we have done what we needed to do and release a report in that context, but also is there an independence mechanism to assess the level of compliance with what should be international best practices in terms of alignment with international human rights law, etc. So I do think that these 4 points present huge opportunity for collaboration between civil society organization and platform. But if I'm going to emphasize on any of the 4, it would be the first point I made about respect for the independence of civil society organization. And I say this as a practitioner, as somebody who has been at that midpoint of trying to be the watchdog and at the same time not getting my friends angry that I'm calling out their companies and all of that. Lastly, I will wrap up with an experience that I had with what happened in Nigeria recently, where the authority fined Meta for allegedly for breaching data privacy law for anti-competition, antitrust practices. And I was invited to a TV station to speak on it, and when I got to the TV station, it was almost like the journalists were putting words in my mouth, like they expected me to just condemn the government and side with Meta, and I'm like, no, I'm not here to do that. And so I felt that there is an assumption that civil society organizations are just stereotype in what they think about the issues, that they cannot form an informed opinion, they cannot have independent opinion about issues. And I do think that we need to see civil society beyond that level, as we exist for the people. We don't exist for private companies, we don't exist for the government, we exist for the people. So whatever is going to happen, what is most important is that civil society must be able to operate with the independence of thought, to be able to assess and to be able to make informed decisions in terms of how best or how well private companies are complying with standards, human rights standards, and protecting the people. Thank you.
Thank you very much for keeping to time. And one thing that also comes to mind while you were making your point, which you kind of touched on, is also a very peculiar issue which is currently raging, which is the access, access of researchers to platform data, especially as civil society in Global South, in Sub-Saharan Africa, and how much access, because if you're aware also, if you follow the development, for example, Meta recently just, closed CrowdTango, which was a very important platform that provided access to data for civil society actors, for researchers, so as to be able to monitor the harms and dangers that platform could cause. But unfortunately, that has been closed. So this could also be one of the areas for that civil society could work together with platform governance in respect to platforms, with respect to addressing some of these issues. So over to you, Gayatri. I hope you can hear me.
That provided access to
society actors for researchers. I'm sorry, there's a bit of an overlap, so you're going to have to give me a few seconds.
So
I could hear my voice still traveling.
Yes, so just give me a few seconds for that audio to finish playing.
Addressing some of these issues. So over to you, Gayatri. I hope you can hear me.
All right. I think I've got. I think we are in the clear, but I can hear my voice. So this is going to be a bit challenging, but I'm going to speak over my own voice. This is sounding okay.
Addressing
kindly hold on
some of these issues. So over to you, Gayatri. I hope you can hear me.
No, it's not working.
Okay, I'm going to try sort of switching off the speaker, so I can't really hear you. So if you need to tell me something, you're going to have to put it in the chat. As the last speaker for this panel, let me first thank you for inviting me, and I'm sorry about all these technical challenges. And I hope I'm able to make a very quick intervention that's hopefully helpful in moving us along in the conversation of how to collaborate between civil society and private sector. Let's first acknowledge the fact that there's no lack of will on either end of the spectrum in terms of wanting to collaborate. Ideally, as the last speaker, I should be putting a positive spin on things and possibly giving us some sort of ideas on how to move forward. But that really is a tough ask, given that the current landscape is what it is. I will still try to remain optimistic and provide some sort of ideas on how we could move forward, I guess. To understand and recommend a solid way forward, we need to acknowledge the current lay of the land. As my colleagues, especially the colleagues who spoke before me, has demonstrated, the challenges are many. At the Business and Human Rights Resource Center, we track and monitor the development on business and human rights standards and human rights violations of over 10,000 companies across the globe. Civil society and media reports pointing to these sorts of violations by tech companies have been steadily on the rise over the last decade or so. So what we did was we recently developed an analysis based on the tracking that we've done over the past 10 years, just looking at instances where we've reached out to tech companies asking them to respond to allegations made by civil society partners or by the media. The key challenge here clearly is the responsiveness of tech companies to requests for information or clarifications. We had reached out in this period of 10 years over 700 times to tech companies about allegations. And in less than 50% of those cases did tech companies respond to us. In fact, that number has been steadily on the decline in the past 5 years alone. This rate of response is lower than what we've observed for the textile, natural resources, agriculture, food and drinks industry. In fact, it's lower than the tobacco sector too. Now, as I said, to me, this response rate is already a big challenge. Now, in 70% of the instances where we've reached out to these companies for asking for a response on an allegation, we noticed that the affected group is usually a vulnerable group such as migrants, children, workers, women, LGBTQI plus individuals, human rights defenders, or media personnel, right? So this demonstrates that the tech sector's disproportionate effect on communities that are already at risk. But what is also problematic is the fact that in over 75% of instances where we reached out to companies, tech companies, about violations, these companies were headquartered in the global north. So what that shows us is that predominantly the effect of violations by tech companies is sustained by people, especially vulnerable groups in the global south, but the companies that are implicated in violations are based in the global north. Another really problematic data point that we noticed is that about a third of the instances where we reached out to companies on allegations, especially by tech companies, were related to violations in conflict-affected zones. So it would either be Myanmar or to Sudan, to the Russian invasion on Ukraine, or in the case of Nigeria. And in 4 out of 5 instances, the companies implicated were in the global north, while most, if not all of these conflicts are in the global south. Now, despite these problematic trends, I would like to move us towards looking at some sort of silver lining. What we did notice is that when we looked at the trends of these numbers, instances where tech companies included some good practices, whether it involved developing business code of conduct, adopting human rights policies, or publishing transparency reports, we noticed that in those cases, the response rates were better. If a company either had a code of conduct, had human rights policies, or transparency reports, they seem to be faring in their responsiveness much better than their counterparts who didn't have any of those three factors that we looked at. I'm glad my colleagues from GNI are also on this panel, because another important data point we noticed is that when a tech company is either a part of the UN Global Compact or the Global Network Initiative kind of, or other MSIs, so to speak, but particularly these two, the responsiveness was better. Now, let me quickly move to the question of stakeholder engagement. About a year ago, and please let me know in text or in chat if I've gone over my time because I cannot hear you. Over a year ago, I spoke to about 40 of our partners along with my colleague, Danny, to get a sense of what are the challenges digital rights defenders are having in relation to engaging with tech companies. Many challenges were mentioned, but what was particularly stark to us was that the Global South partners seem to have a very different set of challenges than the Global North partners. And now this ties back into the fact that most of the tech companies implicated in violations are in the Global North. Inaccessible company structures, not knowing who to speak to, and when we build a relationship with a particular person in a company, it doesn't always bleed into others in the company, and when that person leaves, the relationship with the company as such ceases. The fact that there's lack of whistleblower protections, asking our colleagues to sign non-disclosure agreements, these were all just a few of the examples of what really held people back or made them hesitant in engaging with companies. But really the fact that most of our partners in the Global South felt that there were discriminatory practices by tech companies when it comes to providing information, providing clarification, providing a space at the table for our Global South partners, that seemed to be the unique challenge that stood out.
Gaia, can you hear me?
Which often provided a sense of disconnect, if not disempowerment. Now, in terms of what to do next, we feel that the first step towards collaboration has to be transparency. Now, when we reached out recently to about 104 tech companies on the issue of whether they've done human rights due diligence in relation to Israel's war on Gaza, our response rate was shockingly low. It's lower than anything we've seen at the Resource Center. So we feel that when we are faced with a situation that transparency is not really a given, it's going to be hard to push for collaboration. So the first step has to be transparency and good faith engagement, making it possible for any civil society actor to reach the companies and reach the right person in these companies, adequate follow-up, meaningful engagement, and closing the loops on conversations, making sure that you communicate in a way that both civil society partners and the company officials feel heard. That's critical. Accessibility and effectiveness are key for engagement, just as they are for grievance mechanisms under the UN Guiding Principles on Business and Human Rights. I would highly recommend that all tech companies, especially those with significant user numbers, do proactive and consistent human rights due diligence as a way to know and to show that they're committed to fulfilling their responsibility to respect human rights. All that said, I think it's also worth noting that as defenders, we are also facing an uphill battle. We would therefore also need to invest in finding ways to enhance our evidence building, our capacitation to engage with these companies who are very different in their nature and in requirements, and to also be able to take on the nuances of business and human rights advocacy with tech companies. We need to be able to find ways to coordinate and generate and share more resources to be able to do this together. Now, I'm confident that all of this is within our reach and that with the right impetus, companies will get better at accountability and eventually at the collaboration. Let me stop there.
Thank you very much.
To be able to take on the nuances of business and human rights advocacy with tech companies.
Thank you very much, Gaia, if you can hear me. My theory is that the universe conspired on your behalf to ensure that you overshot your time. But thank you very much. That was very, very incisive, and that gave quite a lot of perspective to some of the issues we've been trying to, discuss. And I fought very hard for this, which is to have some time for just quick question from the floor for the panelists. So please, if you have any question based on the presentation that have been made by each of the speakers, can you kindly please raise your hand? And you have just 1 minute to quickly, thank you.
Bonjour, désolé pour ma voix et je vais y aller en français. Je suis Muriel Alapini, je viens du Bénin et je travaille dans la gouvernance d'Internet. Ok. Ok. Les parties prenantes, les discussions des parties prenantes et tout ça, mais je ne vous ai pas entendu parler des utilisateurs finaux d'Internet, c'est-à-dire moi. Nous sommes en Afrique et nous étions tranquillement en train de vaquer à nos occupations quand Internet est venu nous trouver. Et aujourd'hui, les États sont poussés par l'avancée des technologies de mettre en place des régulations. D'accord. Les entreprises ont besoin de se faire du bénéfice parce que n'oublions pas que toutes ces plateformes-là sont des produits dont nous sommes les utilisateurs. D'accord. La société civile, comme l'a dit Boyer tout à l'heure, n'existe pas sans les utilisateurs finaux, sans la population. Mais après ce forum, après cette discussion, après cette stratégie, moi, utilisateur final d'Internet, je continue de poster comme je veux, jusqu'à ce que la loi me tape dessus en me disant que ça que j'ai posté, je ne dois pas le faire. Donc ma question est, surtout pour la société civile, les représentants de la société civile, pourquoi ou quand est-ce que vous prévoyez augmenter encore plus d'activités de sensibilisation et d'information à l'endroit des utilisateurs finaux d'Internet, toutes ces personnes qui font vivre les plateformes économiquement, elles ont besoin d'être informées, d'être sensibilisées sur tout ce que vous faites déjà maintenant par rapport aux politiques qui existent, etc. Si elles ne savent pas leur devoir, ce pourquoi vous vous battez, leurs droits, je ne pense pas qu'il y ait égalité dans les discussions. Merci.
Boy, I think I heard your name, so that should be.
All right. I mean, thank you for your question, Muriel. I think it's also part of what I was saying earlier, that as civil society organization, our priority is the people. Sometimes we get into some of this conversation at a very high level. We speak technical languages, but what is most important is how does all of this affect the people, the end user, the average man on the street. And that's why I emphasized earlier the importance of socializing rules. It's not just enough to tick the boxes to say we have complied with international norms. It's also to what level are those compliance, socialized among the average man on the street. But you also made an important point around awareness creation for the average person. For example, one thing that have been of great is a trend that I see, that most time when an average person gets maybe experience identity theft, maybe they have a Facebook account, somebody takes over the Facebook account, the guy just moves on and opens another Facebook account. He doesn't care about the one that has been taken from him. So for example, that average man needs to understand that there are policies in place, or there are ways in which he can recover that account. So how does the average man knows how to navigate tech platforms in such a way that they protect themselves from harms, but also in terms of complying with rules. All the platforms now have different rules. There are things that you say, as you said, that you can say, and they're going to take down your account and all of that. You need to be familiar with those rules. But it is not just to be familiar with the rules, but to also be able to give feedback. If takedown of your account represent violation of your right, the platform should not just have the automatic right to make such decisions without also some checks and balances to say that have you acted in the best interest of the people, or have you acted in compliance with existing law. So I think on our part as civil society organization, we have a duty to continue to create awareness, and also speaking within the context of collaboration that needs to happen between civil society and platform. We need to work together to increase awareness among the average man, to also listen to the average man on the street to understand. When I say average man, I mean average woman on the street, to get feedback from them on how their experiences are shaped on digital platforms and the issues that affect them most. I hope my response addresses your concern to an extent, but we can always catch up to have further conversation around this. Thank you very much. Before I yield the mic, I'll have to excuse myself from the room because I need to speak in another session, and they're already calling me it's time for you to speak, so please pardon me. Thank you.
Thank you very much, Boye. You're excused. Thank you.
So I'd like to add to that with a project that GNI participated in, which was part of the Greater Internet Freedom Program, which had some civil society organizations develop reports evaluating local tech companies. And some of those findings were then socialized with the tech companies, and these were about explicitly how to make those policies that already exist more accessible to users. So this includes things like writing them in local languages on the website, making them easy for people to read and access. So just in terms of things like that, we've seen some progress with projects like that, where local civil society organizations work with local companies in order to kind of really explain how these things work, because sometimes they can be very technical. So we think that is a really good step and a good example.
Thank you very much, Montserrat. So I think on the whole, the conversation, the goal of the conversation to a large extent has been achieved, which is to hear from various key stakeholders on how they can engage and work with platforms. And on that note, and on behalf of the organizers, I want to say a special thank you to all the speakers for making time. We're grateful, and I think, and also to you, the participants, for listening. I hope this was useful to you. And on that note, I will hand over to Ian, I think, for the next item on the agenda. Yeah, thank you very much. And that will be the end of this mini round today.
All right, everyone. While I wait for the screen to work, the idea is to have a very quick breakout session, and we're going to be doing this in kind of 3 thematic ways. I think that kind of on the margins and what we talked about today are kind of these key issues as well, but I think bringing them to the surface will allow us to have some more clear insights from you all and also to get your feedback. So I'm just going to roughly say that that white clipboard over there will be those focused on AI and content moderation or algorithmic transparency. The whiteboard over there, we can have information integrity, those focusing on the dissemination of hate speech, misinformation, and other types of harmful content online. And towards the back, we can also have our third group, which is going to be on the impacts of the most vulnerable or marginalized groups that are emerging from platform governance. So I'd like you to kindly gesture your ways in those directions, or if that doesn't work because the room is not divided in a way, what I might also do is provide some guiding questions on the tables for you all, and then give you a few minutes to discuss amongst yourselves any of those topics and then report back on them. That might be a bit more of a flexible option instead of everyone moving around. So just bear with me 1 second. All right, everyone, I realize it's not a lot of time, but I'm going to have to cut you off so we can get out of the room and not get yelled at by the organizers. So I'm going to come to group one to just share your findings and some high points of your discussions. Bridget, do you want to volunteer, or is it someone?
No, I'm trying to figure out how to go about our presentation here. How the patients. I'm trying to. Yeah. Let's see. I'll call on to my people to come in case I forget some points. Because we had discussed some of it, I'll just pick on some of the main points that we discussed right now in terms of the time. Challenges. Adding to what we had discussed earlier in the morning in terms of challenges, where are we? Challenges affecting the adoption of rights respecting platform governance approaches in sub-Saharan Africa, drawing down from issues of lack of political will. Something else that was added was the limited capacity of the different stakeholders who already exist in be it national human rights institution and other policy makers. How can we engage with them? There's still a challenge of how to engage with them and build their capacity so that they have actual knowledge about the instruments that are existing and how we can work together better to address the issues facing platform governance and rights respecting approaches in African context. So limited capacity, but how can we as different stakeholders build on this capacity? And I think something lastly we discussed is even as we try to build capacity, we also have to look at how we can build capacity from bottom up and not to give Kenyans a whole problem because they have an issue with bottom up approach. But either way, how can we build a bottom up approach where we are from the grassroots level empowering even local persons to be able to be active players so that when it comes to engaging, let's say if it's engaging with tech, pushing policy actors, they are all enabled in that regard. So it's not just about top-down, but also bottom-up approach in terms of engagement. There's something here about, help me here, the doctor. Say that. Then there's familiarity with the different, we have different African human rights bodies and we need to make better use of the bodies that we have that actually have human rights mandates and find ways to engage with them, be it through state reporting, be it through shadow reporting, the shadow reports that we engage. But of course, implementation has always been a challenge when it comes to, yes, state reporting happens, yes, shadow reporting happens, but come the next cycle, to what extent have they implemented? It's still something that requires us to engage more with our policy actors. They understand the problem, find the language that is best placed to engage with them. Sometimes it cannot always be confrontation because sometimes they won't, respond to confrontation, but find ways to speak the language of the different stakeholders. And you see and map out who are the different stakeholders. We have policy makers, as we said, there are different policy makers. It could be your policy actors yet at state level. It could be the election management bodies. How can it happen with political parties and candidates? What role can election observer missions play? What role can law enforcement play? So you have to find ways to engage with the different actors so that it's actually a multi-stakeholder approach. Have I forgotten anything? Yes.
We talked about the fact that we do have business and human rights frameworks in most of the SSA countries. It's just that they're overemphasized in the extractives and the mining sector, and not necessarily seen as a tech issue. So bringing and prioritizing tech and business and human rights as an agenda, that should be what we should be focusing on.
Yeah, I agree.
Okay, so okay, in the same vein, my group members, anyone I don't remember, you can. So from us at the AI group 2. So what we discussed, the first thing that we noticed amongst ourselves, at least region-wise, is that there are little or no regulatory frameworks that govern the use of AI, at least from the human rights perspective. So we considered the need for a rights-based framework framework for the whole process, and just to guide the process effectively. So we also looked at whether or not AI captures the concerns for freedom of expression, given our various cultural contexts and language challenges. We're talking about the need to capture the languages, the diverse languages across the region and across the continent as well. We also talked about do we need special laws, existing principles sufficient? What are the risks involved? So, and finally, we considered whether or not AI is better than human modifications with respect to capturing religion and or cultural specifics. So if there was anything I missed, is that all? Okay.
Just a quick addition, really, to note that I think what also came out from the group is that the moderation efforts, especially by duty bearers and folks in the political circles, has triggered the rise of regressive laws that basically are seeking to, criminalize expression that is protected under the freedom of expression. So we're kind of seeing that rising in the effort, and that's really in relation to platform governance. I think in Uganda we still have Facebook blocked simply because of the content that was shared online, and the president didn't like the fact that the content that was really pro his party was banned through the blockage of the accounts. So I think that generally we see that when AI is increasingly used to kind of moderate content, then we start to say it triggers some of those repressive laws.
Thank you very much, Group 2. Round of applause for Group 2. And to the last but not the least group, Group 3, on marginalized groups.
All right. Okay. Thank you so much. I'm going to try to speak for the group number 3, and then if there are anything to add, I will give my co-workers add that. So we were working on the current regulatory trend and action related to platform governance that disproportionately impact the traditionally marginalized group and human rights. So for the first question, so we are a group where we have different countries. So we have tried to give some example relating to some countries. Yes, so we in Nigeria we have the law. Yes, in Nigeria the platform governance, right? And in Senegal we have some law, the law of cyber criminality, and then in Togo, it's like Senegal, we have like the same laws, but those laws are enforced by the high court. So these are the laws, but we don't have a body that exists and which is in charge of those regulations. So these are just the law, and we also have others example like the Senera. I think the representative was here this morning. And then this leads us to the second question, the main challenges. I think we have noticed some lack of will, right, if we can say it like this, of our state government to enforce those laws. We have some lack of will, state reluctancy, right, and also some influence by the platform as they prioritize business. Yes, we can also say it like this. This connection between government and CSOs and platform as far as digital things are concerned. Yes, at the local level, I think there are key players. For the question number 3, are local stakeholders familiar with international guidance to inform right-respecting approach to platform governance? So yes, I wanted to give you the floor to, okay, all right. Yes, we didn't have much more time to wrap up all this, but I think these are the 3 questions that we have addressed. Thanks so much.
All right, everyone, thank you. We're coming to the end of our 5 hours together, so I would like to make some concluding remarks. First, by thanking all of you for coming today, sharing your experiences, sharing your insights, working together, and kind of tackling with these issues in without injury. We good? Okay. That's when you know it's the end. But really I'd like to extend a heartfelt thank you to the speakers, the moderators, and those who came from afar to really contribute to this event. Appreciate it so much. I think that there's some high-level things that came out to me. That one, that socialization is needed, and kind of awareness sharing is kind of key. I think we saw from the panels and the different groups and discussions that there are kind of a number of laws and policies that are being proposed at this point, whether they're kind of singular or overarching and addressing specific issues. We're seeing that they take vastly different approaches. We're seeing competition was raised. I think the lesson from Nigeria shows that you can do things in a more multi-stakeholder fashion, but trust is necessary to do that. So those are a few things that came out to me. We also saw there's lots of international guidance and standards that exist and that are being developed, which can be implemented, but it's important to do this in a rights-respecting manner, to consider local context, and again, to bring in voices and the stakeholders that matter in its implementation. And also, I think we've seen that there's a range of efforts in terms of multi-stakeholder collaboration and the kind of actions of corporate actors. Some more positive. We heard from Meta today in terms of their approaches to takedowns and transparency and stakeholder outreach. And then comparing that with TikTok, where it was joked, like, do I need to get on a plane and fly to Europe to speak to someone there? So I do think that there's a broad range of kind of efforts that need to be undertaken, and that there's no like magic bullet or silver bullet to be said, but I do think that we can take these efforts and taking them at a regional level with regional actors in cohesion with one another is pivotal. So from heartfelt thanks from Global Partners Digital, from the BTech Project, and from Paradigm Initiative. Thank you all so much. We're around for questions and over the next few days, so thank you. Yeah. Cool.